Forest person make a notice to our motor accident happened. Accident. Okay. I don't know the petitioner.
But affidavit is ready,
My lord,
but I could not take it up, my lord. That's why it could not be. Kindly give me
matter is
2 days time.
matter 2010 matter, my lord. 2000.
No,
Yes.
my discussion. Kindly seize, my lord. It is absolutely ready. It has not been affirmed. Kindly give me some time. We will come from Mithilawat. I'm really sorry, my lord. Due to my ill health, I could not take it up.
Like advance copy we serve, my lord.
Yes,
So, my
I
lord,
will give.
I'm
I will give him. 7 दिन time दीजिए तो some more.
The learned
my
advocate
lord, in this,
representing
I
the
interrupt, my
state
lord.
submitted to have prepared the affidavit in opposition,
Supplementary
which,
number,
however, had not been affirmed and sought for a week's time. Next date be fixed on 20 August
my lord,
for filing the affidavit in opposition, serving a copy of the same upon the learned advocate representing the petitioner.
my lord, in this proceeding, my lord, I use a supplementary affidavit that was already accepted by the court. Copy was already served, but
Direction was passed.
they have not used any affidavit or also the
And
supplementary.
the order, there was no direction to file.
Sir, whether you are willing to file anything.
Then, my lord, longer time is required.
So you file this and thereafter we'll see.
Yes.
Next.
Yes, deep level, my lord.
কত তারিখে বললেন গেছে কত তারিখে বললেন এই ফলন
The instant appeal was listed,
বড়
being mentioned. However, none appear to represent either of the parties on call. The Register Administration LOM is to serve notice upon the petition, the appellant as well as the respondents, intimating the next date of hearing. We file a compliance report. Next date be fixed on 19th of September. Next.
My lord, the three is insurance appeal. Pursuant to the order of this honorable court, my lord, the entire awarded amount has been secured before your lordship's court. My lord, it has not come up at Mines test. Yeah, can you mention for it? My lord, this appeal was on the ground of gratuitous passenger. My lord, the victim was going in a tractor. My lord, the insurance company did not cover the insurance coverage of the deceased.
No. What about the stay? It has been made absolute.
My lord, this stay has been made absolute, my lord, by virtue of an order dated 22nd March 2016, my lord, by the Honorable Division Bench. 22nd March 16.
Who is appearing for the respondent?
Yeah, I am for the respondents.
Have you filed the wakalatnama?
Yes, you have. I have filed the wakalatnama.
Who will file the paper book then?
Purve? My lord, I'll file.
The learned advocate representing the appellant insurance company intends to file the paper book and the same is allowed. TCR is there.
My lord, TCR, my lord, it is.
Do you need the TCR to be?
My lord, I need the TCR. My lord, I do not have the documents with me. Certified copies are not available.
Learned Registered Judicial Service is to call for the TCR from the concerned learned tribunal prior to the next date of hearing. It's from which district?
My lord, this is from Purulia.
Huh?
Purulia.
Next date we fixed on 4th of September.
Both of
Yes, for the TCR.
or the TCR. Lordship.
For the next date we fix on 5th September. Department is to place the TCR on record prior to the next date of hearing. Next.
Grateful to your lordship.
My lord, I am for the appellant.
In this matter, I am for respondent cross object.
My lord, in this matter, my lord, stay granted, entire amount deposited, but stay was not disposed of pending. And my lord, only quantum of compensation.
Stay was not disposed of.
No.
What stay was not disposed of? But
Stay application pending.
where is your challan? So these are the original copies.
Original.
So you come at 2 p.m. You file the Xerox copies.
Much.
Next.
I am for
For the respondent.
one point. Exclusive, I am for the appellant. This is the only issue of quantum. Mr. Roy is appearing for the insurance company. Or I am filing paperwork and accepting paperwork.
Paper book filed by the learned advocate representing the appellant claimant be kept on record. The learned advocate representing the respondent insurance company is present. Next date we fixed on 10th of November.
For the petitioner in this matter, my lord, there was a application for substitution, and in that application there was no averment regarding how the applicants are interested in carrying on with this proceeding. So, my lord, I have made an application for amendment. Yesterday it was filed, praying for incorporation of that particular averment. CAN 4.
The learned advocate representing the petitioner submitted to have filed an amendment application to the
CAN 4 of 2025.
to the early. Did you file a fresh or
No, my lord, it's an amendment application for amending the substitution application.
So what is that substitution application number?
The substitution application was filed afresh.
What is the number?
My lord, I'm giving, my lord. It is 3. CAN 3 of 2025.
CAN 3 of 2025. The department is directed to place the records of the aforesaid amendment application along with the
But 3 is before your lordship, I believe.
on the next date of along with the main file on the next date of hearing. Next date be fixed on 18th of August.
19th, my lord. To be honest. My lord,
19th.
my lord, can it be 18th, my lord?
I said 18th only.
18th, I heard 19th. I'm extremely sorry. 18th.
কি করে 4 হবে আমি বলছি amendment
And I have the respondent number 2 and 3.
My lord, I am for the petitioner in this matter. But this is a matter challenging dismissal from service, and the affidavits is complete, pleadings are complete. So, my lord, may I place this, my lord?
yes.
Now, my lord, in this matter, the petitioner was removed from service on an allegation that he had committed certain corruption, falsification of documents to withdraw money from one of the vendors of the respondent company, that is Select and Forest Products Export Promotion Council. Now, my lord, the peculiarity of this case is that the management of the company, they lodged a FIR with the Hare Street police station. Consequent to that FIR, the petitioner was arrested. Then he was released on bail. The criminal proceeding continued. In the meantime, the petitioner was dismissed from service without holding any departmental inquiry. He was dismissed from service on the plea that the petitioner has admitted his guilt. Now, at that point of time, the
Where
dismissal.
was he in service?
My lord, he was in Select and Forest Products Export Promotion Council. He was in service. He was removed in 2000, in the year 2000. Now, my lord, thereafter, the criminal proceeding continued. Trial was held, and after full-fledged trial, the petitioner was exonerated from all charges. Now, he made an application before the employer for his reinstatement. That was not considered. So, therefore, this writ petition was filed. Now, my lord, before going into the...
You mean to say that disciplinary proceedings were not instituted against
No,
him?
my lord. Because an FIR was lodged against me, on the same allegations, I was removed from service. Subsequently, the respondent has come up with a stand that I have admitted my guilt. And they have annexed a alleged document with their affidavit in opposition, that is a letter whereby I have admitted my guilt. Now, my lord, the issue is that a piece of paper containing allegedly my signature does not constitute my admission of guilt unless in the departmental proceeding I am given an opportunity to confront that document. So there was no institution of departmental proceeding. That is my simple case, my lord.
You were not asked to show cause?
No, my lord. I was straightway removed from service. A dismissal order was passed.
Where is it?
Dismissal order টা বার কর।
India affidavit in opposition. Page 21.
Page 20 দাঁড়া, এটাই হবে।
ওদের affidavit in
আমি ওটাই বার করছি, দাঁড়া। The pagination নেই রে।
printed গুলো pagination.
My lord, kindly see annexure R8.
Opposition.
It is affidavit in opposition, my lord. This is perhaps the last page of affidavit.
Never served upon.
And this document was never served.
No.
My stand is this.
What is your name?
My name is Jagjivan Ram.
Jagjiban Ram.
Now, R2, page 20. We have received your letter of resignation, dated such and such today, which is still under active consideration of the committee.
But it was not accepted, my lord. I was asked to.
So you had submitted a letter of resignation
Resignation.
contrary to your claim that you had been removed.
No, my lord. I had submitted a letter of resignation, but that was not accepted. Then subsequently, I was removed. I was removed from service. The document is page 21. And 20 is the FIR.
Where is your letter of resignation? When did you submit the letter of
It
resignation?
is sometime in 2020, my lord.
Is it R1, page 17?
13 is the resignation.
13, but that was not accepted. 13, my lord. But it is for due to his suffering from prolonged illness. He submitted a resignation.
তারপরে পেজ 14 এই যে মাধ্যমটা পরে দেখুন বলছে ইট ইজ আন্ডার অ্যাক্টিভ কনসিডারেশন
ঠিক আছে, it was not accepted. And it is not the stand of the respondent that I have resigned.
Later on, I came to know that on an order sheet, my confessional statement was recorded. And such confessional statement was also considered by the committee in its meeting held on such and such.
Page 20.
Yes.
My lord.
He has been attacked by them to show that this has been
Now, my lord, my very straight and simple case is that disciplinary proceeding was not held. It was assumed that I have admitted my guilt. Now, my lord, whether I have admitted my guilt or not, that has to be established by way of a disciplinary proceeding. So it was not done. And I have been acquitted after full-fledged trial in the criminal charges. And the most intriguing part in this matter is the document which was which has been claimed by the respondent to be my confessional statement before the employer that I have committed some corrupt practice. That document was not made an exhibit in the criminal proceeding. In the entire criminal proceeding, where the chairman of the or managing director of the employer company was one of the witnesses, prosecution witnesses, that document is not there in the criminal proceeding, not in the list of exhibits, neither it was discussed in the criminal proceeding.
Did that person appear before the court?
My lord, the prosecution witness number 1 was the managing director or chairman. Chairman of the employer company.
If he was the PW1, as you are saying,
PW1.
his evidence must have been recorded by the court.
Well, his submissions has been recorded. I have gone through the entire judgment of the learned trial court. The mention of that document is nowhere there. In fact, the judgment of the learned trial court emphasizes on the fact that
the document was marked as exhibit.
The document was not there in the exhibit list, my lord. Huh?
So they mustn't have placed it before the court. This is your crux. Anything else?
My lord, this is my crux, and I will rely on a judgment of the Honorable Supreme Court, which is in the facts of this case, which is applicable. The ratio of that judgment. Now, ওইখানে আছে এটা রূপ আচ্ছা আরেকটা কপি মানে this is reported in 2009 volume 2 Supreme Court cases 570 Rup Singh Negi. And my lord, before I close, my lord, one point was taken by the respondent that this application, this writ petition is not maintainable here. It should go before the labor court. Now, my lord, I have brought the rules of the respondent company, my employer company, which says the managerial staff, in case of managerial staff, any dispute regarding their service will not come under Industrial Disputes Act. The rule is there, my lord. I'll
What was his post? What was
It
his
is-
designation?
He was secretary. He was secretary,
Secretary to?
acting secretary to the company, to the respondent company. My lord, grade 2. He was a grade 2 employee.
Criminal officer and
Huh.
acting secretary.
My lord, it is in page 2 of this. I'm giving a copy of the. Wait a minute. Barcode. My lord, grade 2 is assistant secretary, administrative officer, technical manager. Office assistant, grade 1, assistant, grade 2, research assistant, field officer, export promotion officer, or liaison officer, project officer, or other officer whose basic pay is 5,500 or above and not more than 8,000 per month. Now, my lord, kindly come to page 7. Page 6. The last 2 lines at the bottom. The provision of Industrial Disputes Act 1947 shall not be applicable to those employees who are in service in grade 1 and grade 2 post. And in the opposition also, it is an admitted position that I am the secretary.
So you fell within the ambit of grade 2.
Grade 2, my lord.
Anything else?
No, my lord. This judgment I am relying on. Nothing.
Yes, sir.
But please come to paragraph 3 of the writ petition. Page 4. That your petitioner, while in service, the chairman of Shellac Export Promotion Council, S.S. Saraugi, at the relevant time had lodged a written complaint with Hare Street Police Station.
Which page?
Page 4, paragraph 3 of the writ petition.
Yes.
That your petitioner, while in service, the chairman of Shellac Export Promotion Council, S.S. Saraugi, at the relevant time had lodged a written complaint with Hare Street Police Station. Inter alia, that your petitioner had dishonestly procured a bill for a sum of rupees 33,700 and also forged a letter dated 24th March 2000 and also forged signature of the proprietor and fraudulently used the same as genuine with a view to receive payment against the forged bill. Your petitioner had received part payment of rupees 15,1700 against forged bill prepared by your petitioner. And after the second sentence in paragraph 2, not what remains.
That's allegation. That's
Now,
mere allegation.
apropos this, please come to page 15 of the opposition.
Page?
Page 15 of the affidavit in opposition.
কত বললে সমুদা?
1-5.
ওই লেটারটা।
Yes.
I, J. Ram, son of late so and so, hereby confess that I have procured a false bill from Gopal Dasgupta Khunti, being number so and so, dated 27th October 99, for the value of rupees 33,700. I have also forged the letter of 24th March 2000 in the name of S.S. Saraugi and have also forged the signature of Sri S.S. Saraugi. I accept my complete guilt as far as this instance is concerned. I make this admission on my own free will without any compulsion in the presence of the members of the committee on 14 July 2000 in the meeting hall of the council.
Yes. So based on this, you have taken the action.
But he was heard at a meeting held for this purpose. He wanted to tender his resignation and go away. And when this surfaced, then what we kept this resignation letter on hold and confronted him with this allegation. So he was
So
called at
when
a
was the complaint lodged?
The complaint was lodged on 22nd of August 2000.
And when did he submit his
6th
resignation?
July 2000. And the meeting of the council was held on 6th July 2000 itself.
So, but complaint had come again? What's the
6th
date?
July 2000, he was confronted with this fact which surfaced. 6th July, he tendered his resignation. So after a preliminary inquiry, this complaint was lodged with the police authorities.
When? After he tendered his resignation?
After his yes. 6th July, he was confronted in a meeting. But this is the thing which has surfaced against you. Immediately, he tendered his resignation. That was not accepted.
But this confession was recorded on 14th of July.
When he was again asked to appear at the hearing. 6th July, there was a meeting. Please come to page
You did
11.
not issue any show cause notice.
Please come to page. Please come to paragraph page 14 of the opposition.
Page 14 বলছো?
Page 14. 6th July 2000. A copy of the letter dated 24th March 2000, purported to have been written by Shamsundar Saraugi, was shown to members, and on behalf of Sri Saraugi, Sri P.K. Saraugi, brother of Saraugi, stated that no such letter had been issued by Messrs. Shamsundar Saraugi. Further, he also stated that the signature appearing thereon was not that of Sri Saraugi, who is the proprietor of Messrs. Shamsundar Saraugi. While the meeting was in progress, a resignation letter of Sri J. Ram dated 6 July 2000 addressed to the chairman was received, and it was decided to keep the same under active consideration. It was further decided to instruct Sri J. Ram not to attend office and present himself as and when required. 10th July. It was decided to call Sri J. Ram to appear before the committee on 14 July 2000 so that explanations could be sought from him instead of issuing any show cause notice as had been decided earlier. Then please turn over the page to 15. 14th July, he attends the hearing. And submits this confession letter.
Now, did you inform the respondent authorities about your order of acquittal?
My lord. My lord.
Where is it?
My lord, it was
Yes,
I
please,
sent a letter.
no, it's the
It is a representation annexion number P2. P2.
he was terminated in 2000, October 2000. The acquittal is in November 2009. 2010. Now please come to page 17 of the writ petition.
Yes, against this,
No, 2009. Writ of judgment 2009.
any appeal was preferred by the state?
No, my lord.
Now please come to internal page 4 of the judgment of the learned magistrate. Probably running page is 21. It is the second paragraph on that page. It is transpired from the evidence of PW2, who is investigating officer of this case, that specimen signature of accused was not taken by him for sending the same to the expert for giving his opinion on examination and comparison with the admittedly genuine signature of the author, S.S. Saraugi, whose signature was allegedly forged by the accused. Apart from this, the prosecution has not brought any other evidence so that this court could come to the conclusion that the accused had forged the signature of PW1. It is the case of prosecution that the accused had forged the signature and thereby fraudulently received money showing forged documents genuine. Please keep over the next paragraph. Last but not the least, apart from the negligent investigation, the prosecution has not taken sincere effort to bring de facto complainant and other cited witnesses to establish its case. So I have no hesitation to say that the prosecution was not keen to establish the case rather acted negligently. Having regard to the above facts and circumstances in the midst of evidence on record, I am compelled to say that the prosecution has miserably failed to prove the charge against the accused. I am not forgotten to say that this case is failed for sick investigation and for want of cogent evidence. So, what principally weighed with the learned magistrate was the failure to send the specimen signature of the accused for handwriting expert's opinion.
So was it their fault?
No, it was a. No, I don't say not. There is no difference between an honorable acquittal and an acquittal in criminal jurisprudence. But as your lordships not have coined this expression, honorable acquittal would mean an in-depth consideration of evidence which is not suffering from a faulty investigation. But these two stand on a different pedestal and have different platforms for the purpose of consideration. One is loss of confidence. The other is admission before the employer that there is a forged signature and I have earned benefit out of this forgery. Out of 33,000 rupees, 15,000 rupees he has benefited himself of.
That is nowhere on records.
Now,
I have benefited my bank statement. There's nowhere on records. My lord, I'll indicate one particular thing to cut the things in short. My lord, kindly see when the date of alleged admission by me before the employer that I have committed forgery. That is 14th of July. 14th of July 2000. And the FIR to the police is 22nd August, more than a month after my alleged confession. This document was not put forward by my employer, which is the main document according to the respondent to establish my guilt before the investigating authorities. What precluded? I understand the Honorable Magistrate has observed that prosecution has been negligent. Has the employer been vigilant? What precluded the employer from presenting this document before the court or before the investigating authority? And my lord, this is all going, another document my learned friend has relied on, that is one minutes of the proceeding. My stand is this document, page 14, that document has not been given to me ever. And where is my signature? It is one page. It doesn't contain my signature. I can make two documents and I can claim this proceeding has happened.
That's why that's why I preliminary objection.
I was never given this copy.
These are all disputed questions of fact which the petitioner is inviting this writ court to go into.
No, I'm not. Writ court also has to see whether the procedure established in accordance with law was followed in my dismissal or not. That is my simple question. It is my learned friend who is bringing all these matters of evidence before this honorable court.
Yes, sir.
My simple case is whether the procedure was followed or not.
My simple answer to this is what is admitted need not be proved, as we understand within the meaning of section 3 of the Indian Evidence Act.
An admission has not been established. That is my case. Through due process of law.
The affidavit in reply to the writ petition also does not deny this.
Okay,
But
so
if
heard the submission
I have
of
denied in
learned
my affidavit
advocate
in reply. This
representing
point
the
came up for the first time.
petitioner as well as the respondent at length. Next date be fixed on 12th of September for orders.
My lord. One paragraph file kothay bol.
Next.
No, take us. I have stated in my affidavit in reply that this is a manufactured document.
Next.
Well, I am waiting for the petition. But I am filing for notes of argument.
No one is appearing for the respondent.
Mr. Pithu Dudoria is appear last document. On 17th April, my lord, Mr. Pithu Dudoria.
Yes, sir. Tell me.
My lord. My lord, there are some penalties. I am only two penalties I will attend before my lord. Kindly come to page 17 of the writ petition first.
Yes.
My second paragraph, therefore, in exercise of powers
conferred by Rule 29A, Schedule 2 of Rule 97, it is ordered that one annual increment of such and such is stopped with cumulative effect. But relevant rule does not give power to the authorities to pass such order. Second, my lord, page 18 and 19. Come to page 19, my lord.
Page
19.
yes.
Second paragraph. The increment of such a is withheld for a period of 1 year from the date of forgive with cumulative effect. This my humble prayer, my lord, this cumulative effect portion should go. That I have judgment through 3 judgments I have given, my lord. The various judgments that in both the orders, this cumulative effect portion should go.
Why 2 orders?
Others, my lord,
Why 2 orders? You have shown 2 orders,
my
sir.
lord, two orders. My rest I will not. Rest I will not tell, my lord.
So he would go on repeating this on several occasions.
My lord, my respectful submissions, my lord, authorities has to impose penalty as per the statute. That must be provided in the statute. That Supreme Court first order I have given, kindly see. I have annexed.
Leave it aside, sir. I'm asking you that he had been repetitively committing these kind of nuisance. Yes or no?
Yes, ma'am. But I am challenging only 2 now. Can you see the Supreme Court judgment I have annexed? First answer, my lord. 20125 basis 242, paragraph 21.
Okay, Asha.
My 2 judgments of similar type I have annexed, my lord, though they are kindly see the statute first. This is the statute, my lord. For penalty
Written notes filed by the learned advocate representing the petitioner be kept on record.
in these 2 matters, Rule 69 would be applicable. My lord.
So what about 31D?
31, my lord, there is no specific answer with cumulative effect. Only simple. Stop increment, stop by simplicity.
এই আদিত্য এটা একটু লিখে রাখুন। On this 31, section 31.
My lord, this book only I am having one.
Rule or a section?
My lord, 2 judgment passed by this honorable court also annexed, my lord. Rule has been examined there.
কি বললাম? Learned advocate representing the petitioner be kept on record. Heard the submission of the learned advocate representing the petitioner. None appeared to represent the respondent. Is it CISF?
My lord,
CISF. Next date be fixed on 15th of September for orders. Next. এটা একটা অন্যরকম rules. Next.
My lord, the
Spanish Transport Corporation.
last occasion, my lord. Kindly see order dated 25th of June. 25th of June.
Yes. Where is your senior?
My senior is out of station, my lordship. So,
State also is not present. My lord,
so we have already filed the affidavit of opposition.
So you come at 2 p.m. You come at 2 p.m. Aditya. You come at 2 p.m., sir. Next.
I'm grateful, my lordship.
Yes.
Better your lordship directed me to file a written notice of HON'BLE.
Yes.
Lord, I could not here. Each time lordship had to file that written notice of HON'BLE.
Sir, you need not file the written notes. If any clarification is required, maybe I'll ask from you. Because it's been since March, this has been pending.
Lordship, at the last chance, lordship, I'll give you 2 weeks time.
What is the issue?
Unauthorized action. Unauthorized action.
Removed from service or
Dismissal from service. He was
No.
declared deserter, my lord. He made there was a sanction leave. Thereafter, overstayal. For that, he made an application. Initially, we rejected it. We said that no, you join the service. He didn't do it. Then the second application, then third application, then fourth application. After fourth application, my lord, there was a one-man committee. By us, one-man inquiry committee, and thereafter he was declared as
permissible
deserter
under the rules?
under the rules. He was declared as deserter, and an apprehension roll that was issued. Thereafter, what he did, he submitted a letter tendering his resignation. We said that no, we cannot do it. As soon as you have been declared as deserter, so therefore you will not accept your resignation. Then the disciplinary proceeding, and there, my lord, we gave him a show cause, and thereafter to file a representation. He didn't do it. Then ultimately we had to, my lord, dismiss him from service. That is the main case. In my notes of argument also, therefore, I didn't go into any question of law, only the fact, and thereafter upon the witness body principle, I just
He participated in the proceedings?
no, he didn't participate.
You issued a show cause?
Inquiry proceeding was held.
Inquiry proceeding was held, but there was no representation on his behalf. He was given the show cause that you kindly give your representation. He didn't do it. In terms of rule 18, therefore, my lord, we dismissed him from service. Your lordship may kindly come to the order of dismissal. That will.
My lord, I took the point in this matter because there is no brief with me. I took the point.
Do you have the original case record with you?
No, that I have to, my lord, bring it then.
You
If your
place
lordship
it on file?
SSB, I do not know, my lord, SSB, where is their actual department?
Which
Whether it is Kashmir. Kashmiri SSB কোনো branch নেই, কি বলছিস? Anyhow, my lord, your lordship, give me 15 days time. I will ask them, my lord, to produce the record also.
he was serving in CISF?
No, SSB, Sima Suraksha Bal.
Acha.
And actually, here is, my lord, one person acts here as a liaison, but he is very irregular. That is the difficulty in this matter. A phone number ta ache? Your Lordship,
The learned advocate representing the respondent Union of India is to place the original case records concerning the disciplinary proceedings instituted against the petitioner and resulting in his dismissal from the
yes.
service as a constable.
Yes, constantly.
As a constable attached to SSB.
SSB, Sima Surakha Bal.
SSB ব্র্যাকেটে লিখে দিন সীমা সুরক্ষা বল. On the next date of hearing, next date be fixed on 4th of September.
4th of September.
On 4th of September, you place the
Yes,
case
yes.
record. I'll finish it up because it's
Let's-
pending for long time. Next.
But 24, I am for the petitioners.
I be accepted for the primary school council.
My lord, I am for the state, my lord. The pleadings are complete, my lord.
21st March of 2025, my lord was pleased to direct the state to file an affidavit
Hmm.
for explaining the status and constitution of the primary school council vis-a-vis with the board. Well, affidavit was filed on 18th of June. I have
You wanted to file a.
accepts.
Now tell me what's your case?
My lord, can it be
Well,
taken up for hearing on next week, my lord? I'm led by Mr. Bandopathy.
So he will start. What is your problem?
In 2006, the present petitioner was appointed as contingency staff in Makura district primary school council. Thereafter, he was selected as Group D employee in the said council. But since then, he is discharging his duties as Group D in the said council. In 2010, my lord, he applied for promotion. After compliance of all formalities, the respective authorities.
After serving for how many years did he apply for?
After 3-4 years, 4 years.
So was he entitled to do that after serving 4 years?
At that time, as per prevailing rule, 10% of the post of promotional post, that is the lower division clerk, was to be kept vacant. So within that category, my lord, he applied for promotion. Initially, his case was not considered. He came before this honorable court. This honorable court, by passing an order, directed the concerned authority to immediately consider the case of the petitioner. After communication of such order, my lord, his promotion was granted. But no financial benefits were released in his favor. Thereafter, he repeatedly sent one after another representation to the authority. Suddenly, my lord, the order of promotion was revoked or cancelled by the said authority. Challenging that order of cancellation of promotion, this present writ application has been filed. Now, my lord, in course of the hearing, on few occasions, this matter was heard by your lordship. We have placed our case. The primary school council, my lord, came up with a affidavit disclosing that in terms of recruitment rules of 2007, the post lower division clerk is a direct recruitment. That is not the promotional post. That is their case. My submission was before your lordship on the previous occasion that in terms of circular of 1995 of the finance department audit branch, I am entitled. My appointment was initially made in 2006. So 2000 circular will not come in my case. This is my case.
Show me those circulars.
But they have annexed in their affidavit.
By the respondent number 4 and 5, affirmed on 23rd September 24.
Is it annexure R1?
My lord.
আমাদের
ওটা
No, no,
ওটাই বলছি।
state affidavit.
State affidavit is also they are relying. Same.
Yes, which paragraph? Which rule?
My lord.
Technical primary. R1, R1.
R2. Their affidavit R2 page 93.
Page?
93.
There is no page 93.
The last affidavit state has used.
My lady, even on my lady, on our affidavit, state's affidavit is a little.
Equal, my lord.
thicker. We have also relied on, but since is
Council had also affirmed an affidavit. It was affirmed on my lord.
Amar.
affirmative date of
13 June.
13 June.
Yes, page number 93. West Bengal Primary Education.
Yes.
Appointment and punishment of staff, primary school council rules. That
Yes.
one?
Yes.
Which rule?
Well, I'm
125.
তোমার কাছে আছে?
125.
27.
That's rule 27.
Yes.
Repeal and savings.
Yes, what is it?
103, my lord. Running page.
103,
my lord.
And 3.
Lower division clerk.
At the top, your lordship will find name of the post mentioned in column number 2 to be filled up by selection direct recruitment.
So you appeared for the examination?
No, I was appointed as Group D. I opted for promotion from Group D to lower division clerk.
So, but then it is.
In their case, in terms of 2007 rules, the lower division clerk is a by way of direct recruitment, you can be appointed. Serial number 4, the lower division clerk.
Yes.
Mentioned. At the top, they are saying that in terms of rule 2007, this post is only for direct recruitment.
To be filled up by selection.
By selection.
Direct
It
recruitment.
is not promotional post.
Yes.
My case that I was appointed in 2006. This rule has come subsequently after my engagement. And at the relevant point of time, 95 rules was there. That I have annexed in my petition.
These rules shall apply to the member of the staff other than the secretary and finance officer of the primary school council.
All the present staff rule for all the present staff except these two.
Yes.
This is my case. I have nothing to improve. And 95 circular, I have last occasion I have shown, your lordship has recorded your lordship's order dated 21st March 2025.
Which is a circular that you are relying on?
Yes, that is 95 circular, page 43 of my writ petition.
Yes, which paragraph?
Paragraph, the first paragraph, under the existing rules, 10% of the vacant LD post, lower division post in secretariat, directorate and regional offices are
But this is the notification dated 43.
22nd June 1995. page 43.
Yes.
Under the existing rules, 10% of vacant LD posts in the Secretariat, Directorate and Regional offices are to be filled up from amongst the eligible Group C, Group D employees. A conclusion persists in certain quarters in respect of preparation of the list of eligible candidates for the purpose. It has been observed that almost in all cases, Group C employees are placed above in the list, while Group D employees are placed below in order because of the fact that the former belongs to a scale of pay higher than that of the latter. As a result, Group D employees very seldom get a fair chance of getting selected, almost always being out of the zone of consideration, the position being
okay.
And this is mine.
Ashwin. In compliance with the order dated 18th of June 2025, the learned advocate representing the petitioner has filed an exception. Let the same be kept on record. Heard the submission of learned advocate representing the petitioner, and you are for respondent number
Okay.
1 to 3.
1 to 3.
And you are for
DPSC, District Primary School Council.
respondent number 1, 2, 3, as well as respondent number 4 and 5. 4 and 5. Let the matter be fixed on 19th of September for orders.
My lord, we will be getting a chance on that particular day to rebut, my lord. 19th of September, my lord.
For order.
What will you rebut? Next.
Get.
$29, my lord, I am for the petition.
Yes.
On the last occasion, my lord, there was a direction to file a report.
On the last occasion, your lordship directed to file a report regarding the disciplinary proceeding, status of disciplinary proceeding against the petitioner, my lord. Along with tendering my apology, I humbly beseech your lordship to the extension of 1 week only. On the 24th, my lord, the deputy director, his father died. After fortnight, your lordship provided fortnight time. He joined on 11th, and 11th he was intimated to report to Delhi office on 12th. My lord, he's still in Delhi. He will be there by the weekend, my lord. Only 1 quick time, I beseech your lordship only as a last chance.
The last 2 occasions, they
Today it
No,
was marked as last chance.
Yes.
Today itself,
Lordship,
given to you as the last chance.
I couldn't, my lord. Lordship, under the circumstances, my lord, the bereavement was there, my lord.
File an affidavit stating whatever you said.
Lordship, I tender my apology, my lord. Only a last chance, my lord. I'll file it by the next week, my lord. Definitely, I'll file it. I'm seeking an apology, my lord.
Your apology doesn't.
Gang rape of a for
Has not been
twice, my
displayed,
lord. Different.
Not filed report that is admitted position on last 2 occasions. And on,
Lordship, on that ground, I am praying for mercy of your lordship, my lord. This is the last occasion, my lord. I'll file it definitely in the next week, my lord. Any day your lordship fixes in the next week, I'll file it before your lordship. It was a demanding position he couldn't avoid, my lord. I tender my apology. Kindly, my lord, fixes any date as per the lordship convenient next week. Even he is enjoying 75% of his salary as subsistence allowance. It is not that he is not getting anything. 75% of his salary he is getting, my lord.
as subsistence allowance in suspension, while in suspension.
So you're facilitating him to do that?
No, my lord.
If you are so convinced that
my-
he should be removed, then this
Instruction is disciplinary proceeding has already been concluded, and only the IO report that is going to be submitted, and it is all over. Only that part is there. That is my instruction, my lord. But I will submit before lordship the entire set of status and documents.
What about the criminal proceedings?
It is he is facing the trial.
Still pending.
He is facing the trial. It's pending.
75%
A Japanese national. My lord.
These are all false allegations, my lord. Nothing.
And 2 petitions on this same cause of action, suppressing the first one before Honorable Justice Lapita Banerjee.
You, at this point,
Lordship, I have filed an opposition. Only the status report, my lord. 1 week time, my lord. I'm humbly beseeching, my lord.
if on the next date you do not file,
Lordship,
then I'll
be out of court.
the
Lord. Lordship.
Ashwin.
This matter, my lord, I am appearing for union of respondent number 1.
What is your role?
And I am adopting his, my lord. On last occasion, my lord, I have submitted that.
Who is the person?
My lord, Deputy Director of the Indian Museum here, the Board of Trustees has been delegated the power to conduct litigation and affirm, my lord.
Learned advocate representing the respondent number 2, 3, and 4.
3 and 4, my lord.
Seeks a week's time to comply with the order dated 9/7/2025. Next date we fixed on 20th of August 20.
My lord.
20th August, my lord. Might have some personal difficulty any day instead of before
19th of August. For filing the report in the form of an affidavit, failing which the Deputy Director
Of Indian Museum.
Indian Museum should be present before the court with an explanation.
That occasion won't arise, Your Lordship. I assure you, that occasion won't arise. Grateful, my lord. I am again tendering my apology. Grateful, my lord.
Next.
My lord, I am appearing on
The petitioner, my lord, if the matter can be passed over for some time, my lord, Mr. Dotto is in this matter, my lord. My lord, he is in another
last
court, my
occasion,
lord.
your lordship directed me to inspect the my lord court records, my lord. I have inspected the records, my lord. Can I have a copy of the petition, my lord? I do not have the copy, my
Who are you are representing the
Union of India, my lord. BSF. I'm led by Mr. D.N. Roy, my lord.
What is your name?
My name is Shubhajit Chaudhary.
So on every occasion you come and see.
In another court, my lord.
My lord, your lordship, remember in this matter, my lord, other persons, my lord, approached
him to
before the
come.
Honorable
My
Appellate
lord.
Court.
He will be present, my lord. Kindly fixes a time, my lord. In the time frame, I'll inform him, my lord.
He's not.
Well, I'm for the petitioners.
But I'm, as per Lordship's direction on last occasion to file as affidavit in reply to their two affidavit in opposition and exception. My lord, I am filing this. Thank you.
Affidavit in reply to the affidavit in opposition filed by the respondents to the supplementary affidavit. Dated 6/12/2023 be kept on record. An exception to the aforesaid report filed by the learned advocate representing the respondents be kept on record. Now, what is the issue, sir?
The issue is, my lord, the petitioners, my lord, they were appointed, they were joined as a ancillary staff under the railways in the year 2007. And my lord, thereafter, as per the recruitment rules, Directive 14 was there in the year, it was promulgated in the year 1996. And my lord, in 2012, my lord, the notification was issued for change of category. Because for the ancillary staffs, my lord, under the railway RPF, there was no promotional prospect. For that reason, my lord, the Directive 14 was issued in the year 1996. That was continuing. And the petition was joined in 2007. 2012, notification was issued. The requisite qualification is 5 years service for, my lord, to be treated as a change of cadre from ancillary staffs to constable executive. At 2012, they have submitted their, as per the notification, they have submitted their application. It was continuing, my lord, the screening was made. Candidates, all the petitions have been shortlisted. 2015, willingness was taken, May 2015. After the willingness was taken, May 2015, suddenly on 8 January 2016, the respondent issued a notice that change of cadre is not permissible. Directing 14 have been abolished by the Director General. In the meantime, well, the other railway zone, the notification was the same, similar notification issued. They have permitted to change of cadre and they have joined. But similarly, circumstances they keep it pending for indefinite period. Suddenly, 2016 notification issued, and well, they have taken our right to be considered for the change of cadre from ancillary staffs to constable executive. And immediately thereafter, filed the application before this Honorable Court. This is the crux of the matter. And well, we have filed some supplementary showing that till 2017-18, there was recruitment, change of cadre was permitted. In there, we have filed one supplementary because they have also filed a reply last occasion. And well, from there, the documents, it was transpires that 2018 also the change of cadre was permitted by the railway authorities. And well, the moot question, whether the notification which was issued in 2016, after the...
Was there notification, as you are saying, to have been abrupt against the rules?
It's a directives. It's the rule 20
so
as per
you
the...
mean to say these are all administrative directions?
That is the it provides in the RPF rules. The Director General, we can promulgate it for the furtherance of the welfare of the...
So that is the prerogative given to the railways.
And The 2012, my lord, on the basis of that notification, several other zones they have joined. They have permitted, they have screening was made, shortlisting was made, and they are permitted to change of cadre on the basis of particular notification. But in our case, it was, well, our screening was made, shortlisting was made, willingness was taken. But suddenly in 2016, well, they keep it pending for final, well, the disposal. And well, 2016, January 2016, sudden one notification was issued that you are not permitted for change of cadre.
Was it only for your zone or for across?
Well, the whole. But 2012 notification, my lord, the others have been permitted. They have joined. And that continuing 2018, we have discussed in a supplementary affidavit, that particular documents. Railway board permitted them up to 2018. And only, my lord, whether that notification can be given a retrospective effect. You issued a notification in 2016 that can be given when the recruitment process already been going on. It was in another process. We have been shortlisted. Not that we are not shortlisted. Our willingness was taken. Can you give the 2000 notification a retrospective effect to the notification issued in the year 2012, 2015? Retrospective cannot be given effect to.
You are guided by which notification?
Yes, my lord. Initially, my lord, there was a notification regarding the ancillary stuff for upgradation. That notification was there. But under the directive number 14, that power was there by the highest authority of the RPF. And my lord, subsequently, in the year of 2015, that was withdrawn. So, my lord, as soon as that order was withdrawn, my lord, during that time, their selection was not completed. And subsequently, that was also informed to them.
Now, they were serving
They
at
are
the
serving.
time.
Actually, what happened, my lord, they are.
Did you seek for their applications?
My lord, I am not seeing, personally, I am not seeing that they are individual application. But because, my lord, due to this bar, that is, my lord, that can, my lord, kindly see for a moment my affidavit in opposition, my lord.
কোনটা মেনটা না এটা?
When did you file?
My lord, I have filed, my lord, long back ago. If it is in opposition, actually, my lord, there are various.
Affidavit of privacy, bhoti.
My lord, that was affirmed, my lord. On, my lord, August 2017.
August
2017. If it is in opposition to the writ petition, my lord.
Yes. Which page?
My lord, kindly see the page 14, my lord. That is, my lord, I have annexed, my lord, the relevant rule 28, my lord, the power of the Director General. Page 14, my lord. Page 14, my lord, that rule 28, my lord. I have also, my lord, book is also with us, my lord. the power of the Director General to issue directives. The Director General may from time to time issue such
Now, which
directives.
is the directive that they are challenging?
Yes, ma'am.
Which is the directive that they are challenging?
They are challenging, my lord, the which directive was withdrawn by
Where
the
is that directive?
2015, my lord.
Where is it?
My lord, next page, 15. By this directive, due to this directive, directive number 14, my lord, they applied for that. For from ancillary staff to the higher post. Then your lordship kindly come to the page 16. My lord, that directive was abolished. My lord, New Delhi, August 2015. Abolition of Directive 14. My lord, page 16, my lord. You also got it, that page 16, my lord.
You mean to say the directive in page 15?
My lord, page 15.
Page 15 mentioned directive
two.
number 14.
14.
So this directive number
By
14,
this directive, they applied. But subsequently, this directive was withdrawn. My lord, kindly come to the next page. During the pendency of this, my lord, the selection proceedings, that directive was withdrawn in the year of 2015. My lord, abolition of Directive 14. Consequent upon reclassification of all the posts of ancillary staff of RPF, RPSF as Group C, their placement of PB1 with grade pay of rupees 2000 and re-designation as constable with effect from 1/1/2006 in terms of the Ministry of Railway letter number such and such dated 3/7/2013, RB number 62 of 2013, and issue of instruction for grant of financial upgradation under modified assured career progress scheme effective from 1/9/2008.
takes care of the high availability of higher pay and allowances in lieu of further promotional ranks after their placement and as classification Group C. Were you given
Actually, my
your
lord,
placement in Group C?
Group D abolished. That was, my lord, as per the Railway Authority circular, my lord, Group D post was totally abolished. For that reason, they said instead of Group D, they all are now Group C. There is no Group D now.
So I'm asking you, did you get your placement in Group C?
We are in Group C. We are in Group C.
So, and you have received this MSCP upgradation,
MSCP
financial benefit you have received.
But there is no financial benefit at all, my lord, because the at that point of time we moved before this honorable court for not getting the financial benefit, as they are claiming here now. We have in our opposition, my lord, we have stated that particular, my lord,
my lord, financial upgradation is given to all the employees of the.
No, this there is a reason given there. Read it out.
Yes, my lord. May I read the entire?
And issue instructions consequent upon reclassification
Yes,
of
ma'am.
all the posts of ancillary staff of such and such, their placement in PB1 with grade pay of such and such, and redesignation as constable with effect from 1/1/2006 in terms of Ministry of Railways letter such and such, and issue of instructions for grant of financial upgradation under modified assured career progression scheme effective from 1/9/2008, which takes care of the availability of higher pay and allowances in lieu of further promotional ranks after their placement classification as Group C, Directive 14 by such and such, which was issued by the Director General RPF in exercise of powers conferred upon him under Rule 28 of RPF Rules 1987, read with Section 8 of RPF Act 1957, for change of category from ancillary to constable executive, purely as a welfare measure, is hereby withdrawn with immediate effect.
Yes, ma'am.
So, did they receive the financial upgradation?
Yes.
But this
But they are saying no.
I think, my lord, he's not properly instructed.
So no, that was not given. I have said it in my.
There is a reason for withdrawing this directive or abolishing this directive. And they are saying that the directive was issued purely as a welfare measure.
Because
so if by virtue of the welfare measure, they had issued the directive, and at the time of withdrawing or abolishing, whatever you say, they have granted you certain benefits, and your placement in Group C has been ensured, then what
But
is your
because
problem?
The, my lord, the, as per the because the circular, my lord, the all the Group D posts was abolished. And my lord,
Now you are in Group C category.
But in spite of this circular, my lord, we are in Group C ancillary staff.
That is
my lord, they have
saying.
they just changed the name as a from ancillary to constable. We are still will be all together in a service career. We will all be, to be the constable executive, constable barbar, constable safaiwala. There is no prospect of promotion. That is the, my lord,
That is an administrative issue, sir.
My lord, for that reason, my lord, kindly have a look to, my lord, the directive number 14. Only once, my lord, page 15.
My lord, their challenge is this directive. And my lord, now they are getting the financial upgradation, whatever may be the benefit they are getting.
That is their directive. They have issued.
But coming to that, well, kindly see the page 15 once. Page 15.
Yes.
To provide with a view to provide promotional prospect to those ancillary staffs. So, my lord, the directive 14 was forward promotional prospect. But in spite of, my lord, the withdrawal of the directive 14 part, we don't have promotional prospect. We will be all together in a service career. We will all together will be.
So initially you were in Group D. Now you have been placed in Group C with certain benefits that MSCP.
But now, my lord, in the Indian Railways, there is no Group D. Group D post has already been abolished.
My lord, there is another channel for promotion. My lord, they may apply it for the driver post, and they will be, my lord, get promotion and to the higher rank, my lord. But they have to apply it for that.
We cannot. Now the 2000, that is that one of
So that is for, I mean, you have to.
Well, anyhow, issue is otherwise here.
Promotional rules and all, the court can't frame, sir.
As soon as this,
violation of extant rules, you can come.
my lord, as soon as the directive number 14 is withdrawn, my lord, they have no right. And my lord, the reason of withdrawing, that is the financial upgradation. Actually, at that point of time, there is no financial, my lord, benefit was there. For this reason, my lord, that directive was issued. And when, my lord, that upgradation was there, that was withdrawn.
Have a look to, my lord, the directive 28. Directive number 28, page 14.
14
of their opposition.
My lord, that is not the directive, that is the section 28 of the RPF rule. My lord, kindly see that. That is not the directive.
Yes, they have granted, they have conferred power on the rules. Have conferred power on the Director General to issue directives.
Director General may from time to time issue such directions in the form of directive relating to enforcement.
And that also may.
Enforcement and further.
It is also may, sir, may.
Enforcement and furtherance. And my lord, the directive 14 was also
28 is, my lord, the power of the Director General under the RPF rule.
And only for that reason, my lord.
Okay, sir. I have understood. Ashwin.
Kindly consider one aspect of it. In the, my lord, they have discussed one. We have in our supplementary affidavit, my lord. We have discussed several petitioners. They are also valued, my lord.
No. I have dealt with each and every one.
But only issues, my lord, whether, my lord, they can, when the recruitment process is going on, you have been shortlisted. But whether they can, my lord, they can issue a retrospective effect to the Supreme Court says.
Sir, while you are appearing for any examination, right? Or for that matter, you have been shortlisted. What vested right do you have? What vested right do you have? Tell me, sir. Do you have any vested right?
Right to be considered, my lord, is one of the right for consideration to the particular post. Is a vested
My
right?
lord, even my lord, today, impalment is not also
Okay,
right.
heard the submission of learned advocates representing both the parties. At length.
But I'm relying on the judgment of the Honorable Supreme Court, my lord. Why my lord, the Supreme Court says, my lord, retrospect in their in the similar set of cases, my lord. Similar case, my lord, the Delhi High Court passed a judgment, they relied upon particular judgment. In 2009, my lord, they took same thing. That
Then you file a note. You file a written note.
it is relied on. But 2018, my lord, kindly have a look through the similar case, my lord. Similar case, my lord, on the basis of the order passed by this Delhi High Court, my lord, the division bench, my lord, they have been the persons, my lord, the change of category was
Unreported judgment at a copy.
This is they have relied upon this particular. They have relied upon 82 persons have been appointed. My lord, they have been installed. The notification was issued. On I may base the judgment, my lord. Similar post, similar my lord, issues. The court says you cannot give effect retrospective effect to the notification. And on the basis of the order passed by this court, my lord, this case was there. And there in 2018 they have been appointed. I have discussed in my affidavit of opposition. Whenever a person apply, my lord, they have taken their plea, they have.
My lord, they have been promoted through the driver post, which I have submitted. My lord, kindly see. Yes, my lord. I think, my lord, either he is, my lord, misleading or not properly instructed. I am, my lord, sorry to say, my lord. I have specifically dealt with each and every statement of your supplementary affidavit. 3-4 supplementary affidavit was given, my lord.
Relied on particular judgment. You relied on linear opposition. Linear opposition relied on particular judgment. And you said that on the basis of this order, 82%.
Affidavit in opposition, there is no such judgment was given.
There is some training issue.
They have been on the basis of the order passed by this court, my lord. They have one of the examination was held. Thereafter, they sent for claim. My lord,
There was already a selection.
No,
My lord, from their list.
they filed the application. Court says you
The
cannot.
respondents have thus prepared a panel of 82 candidates who have been duly.
Facts of the case, my lord, starts from.
This is not applicable to your case.
But I'm facing it.
No,
So
sir.
it's applicable, one.
Where is the list here?
My lord, kindly see, I have what I have stated in my statement. The petitioner.
You file a note. I don't have much time now. I have other matters also. Next.
My lord, 4-5 supplementary affidavit.
Sir, you file a written note. Sir, you file a written note if you want to. Right? You take whatever points you have to. I have heard you. Whatever decision you want to rely, you incorporate and file a note. In any case, the decision that you had placed doesn't apply to you.
Yes.
Because in this particular matter, there has been no selection, which I asked you at the very inception. You said no, and it was applicable across India, right? So there was no such selection as applicable to your case?
Sir, can you see my supplementary? I have discussed that document that relied upon particular order. 82
Acha,
persons were
heard the
appointed.
submission of learned advocate representing both the parties.
And my lord, after submission of his written notes, you will serve to me, and I will also, my lord,
Written notes to be filed by the learned advocate
and the next month, my lord,
representing
any
the
day.
respective parties. Next date we fixed on 2nd of September for filing written notes.
2nd
Next.
September. Written notes, my lord. Directly.
You go through it, sir. It pertains to a particular section, a particular which is not applicable to you. Next. What happened to you today? You are not prepared in any of the matters?
One more chance to find recognition.
So did you see the orders? Then?
And last chance, now I can give. That's it, I will give you to explain.
On the prayer of learned advocate representing the petitioner, let the matter be fixed on 21st of August as last chance. 21st of August as last chance.
Master, can you make it 4th September? In another matter, they lost it 4th September. 4th September, Master, can you?
4th September as last chance.
Fine.
This matter already heard by your lordship and has been reserved for.
Which is this? Now, earlier, the petitioner's brother had applied.
Was called for verification, but he didn't turn up. Then subsequently, this petitioner, another son of the deceased, applied. And also, this issue raised by this the respondents have been dealt by the earlier litigation. And technical objections again directed to consider my candidature for approval. So kindly come the order passed by this Honorable High Court on earlier litigation. Kindly come page
35.
Yes, 35. Yes. Now, considering this objection, the Honorable High Court directed to consider by them. And the impugned reason order travel on the same line.
That you are not eligible on the ground of?
That my brother already given opportunity for appointment.
So I did not file the rules here.
Kindly come opposition. I have also quoted that in my written notes of argument. But the rule that opposition starts from page 28, sorry, page 29, clause 6. One of the dependents is second line, clause 6 seconds.
Now, sir, this one, this portion, 6A. The dependent of an employee shall be eligible to apply for employment under this category, provided such death in harness, incapacitated, retirement occurred on or after 6/6/2005, and also the dependents did not receive any financial compensation in lieu of employment. So you have received? You did not receive financial
For the
compensation.
Compensation gratuity provident fund, that is separate thing, but let's say for the employment, no compensation. My father expired on 12 of the 12. 13 December.
Who was appearing on your other side? So you are appearing for the respondents.
What is one?
Yes.
Now you please explain me. Rule 6. And also the dependents did not receive any financial compensation in lieu of employment. So is it distinct from the retirement benefits that you will grant them?
No. Here, my lord, the dispute arises in such a way that the petitioner's son was selected for employment. He has been given offer. He refused to join. Subsequently, after 4 years, another son applied. Now, question is whether the reason for compassionate appointment is for tide over the situation of the family. When the first applicant applied for compassionate appointment and he has been selected, he did not join on that post. Subsequent thereto, another son applied. Now, question in the judge order, in the first order of the Honorable Justice Arindam Mukherjee, in his last paragraph, it is stated, it is however made clear that in the event the respondent number 1 decides to offer employment under the compassionate ground to the writ petitioner, it shall do so as per the prevailing policy of the respondent number 1. So our policy is that the one member will be applied for with no objection from others. Accordingly, the petitioner's eldest son applied for. He has been selected. Date has been, my lord, he did not join on date of joining. He sat over the matter without any intimation. After 4 years thereafter, another son, second son applied for. His application was not considered. Then he moved before this honorable court. Honorable court passed this order. Now question is the policy of appointment in respect of that compensatory appointment. Here, my lord.
So does the rule say that after a particular lapse of time, subsequent applications cannot be made, or it has to be within a particular time period?
In 2010 rules, which I have annexed with that
Because your rule says
Rule 6. Considering the plea of the family after an earning member dies. Then, my lord, one of the dependent of the employee who died in her name or had been declared so and so incapacitated by the medical board constituted the company irrespective of the pecuniary conditions of the family may be offered employment in class.
now, sir, your explanation to this sentence, the dependents does not, and also the dependents did not receive any financial compensation in lieu of employment. Now, in the next page, paragraph clause E. Now it says such unsuccessful applicants, because they have to go through a selection process.
Yes.
And become successful.
First
Criteria. Now it says some applicants can also opt for financial compensation in lieu of employment within 1 year of their being unsuccessful. Financial compensation in lieu of employment will be given in the manner and the rate as would be prescribed by the board. So these are in parity to each other. 6A. 6A says the dependent of an employee shall be eligible to apply for employment under this category, provided such death in harness, incapacitated, retirement occurred on or after 6/6/2005, and also the dependents did not receive any financial compensation in lieu of employment.
Therefore, my lord,
so a person who had been unsuccessful.
No, here is the first clause is suppose a person died. He's here asks for compensation in lieu of appointment by monetary. Then there is a calculation we shall pay him or their family in respect of
the ones who are not seeking appointment on compassionate
compensation.
ground.
A goes here. They have applied for appointment. A is not applicable here because his son applied for employment. Accordingly,
so they didn't seek for
clause A.
They did not seek for the financial compensation since they had already applied for appointment on compassionate ground, right?
Yes.
And the ones who are unsuccessful in the selection process, they are also granted financial compensation as per clause E.
Such unsuccessful applicants also can opt for financial compensation in lieu of employment within 1 year of their being unsuccessful. Therefore, suppose first person who unsuccessful in examinations, there is process of selection. He may apply for compensation.
So you are granting financial compensation on 2 grounds.
Yes.
One, who are not opting for compassionate appointment, right? And the others who are applying, but they are becoming unsuccessful.
They
Then
can
also you are granting them financial compensation.
if they applied within 1 year.
If they apply within 1 year.
Yes. Here the first
They had opted, they were selected,
did not
you
join.
had asked them to come and join, they didn't. And after 4 years, the other son comes.
Other son applied for.
So
3 years. So 7/6/2016, they applied.
now you have not mentioned any particular time period. I mean, the rule doesn't mention any time period. And whether on rejection of, if somebody doesn't apply, if somebody doesn't join, whether it is
Right goes because one employee, first clause, one of the dependent, rule 6, the right, if they did not apply, join.
So the rules doesn't mention so.
This one of the dependent of the employee who died in harness or had been declared physically incapacitated by the medical board constituted by the company, irrespective of the pecuniary condition of the family, may be offered employment. Class 3 of one of the employee, one of the dependent. He applied for, he has been selected in due process, he did not join. After that, sat over the issue.
The other son will say, I was also dependent. The other son might say that I was also dependent.
But at the time when he applied for, first son applied for, he has given no objection. All the family members have given no objection for appointment his elder sons.
But you have not mentioned any time restraint.
As regard
the applications.
As regard the applications.
That is not there in the rules, sir. If the rule doesn't even say if the selected candidate doesn't join, the entire process becomes barred.
No, there
for
is
others to apply.
Rules is
Now
clear.
you said one of the dependents.
One of the dependents.
So the first dependent says, I am no longer the dependent. That is why I have not sought for your appointment. The other would say that I am dependent. Then what will you do?
No, that's why, my lord, on the application form, we have provided for no objection from other legal heirs. When other legal heirs given no objection, then we shall consider his candidature. If suppose,
so you mean to say that when the first brother applied, the present petitioner had already granted no objection.
Yes.
So by granting no objection, he had precluded himself from claiming the same right.
Yes.
This is your contention.
Yes. And if that be so, in suppose after appointment someone has been not joined, then another, in the meantime he obtained. Here in particular case, it has been in before the authority, it has been stated.
Okay, sir.
We have already engaged in the panchayat members.
Wanted to know whether the time has been mentioned, because I did not find the time. And the
Section of page 28, the given for the appointment. Not only that, not this issue, they cannot elevate again because this issue has been considered by the honorable coordinator.
There is a government notification
and
consider afresh or pass a reasoned order.
Kindly come to the order of honorable signature.
No.
Which page?
Page 35. The case may be considered by the employee of resident of state. Since it is pointed out the application made by the effective as a special case afforded a parental submit the application with the reference number 1, 7 days from the date. Number 1 to apply the proper application form to the 5% time frame.
Yes.
The event such application made out official of the
Yes.
Yes.
It is, however, made clear that
Yes.
in the event the respondent number 1 decides to offer employment under compassionate ground to the writ petitioner, it shall do so as per the prevailing policy of the respondent
Yes.
number 1.
So also the passing of this order, also the issue, the defense which has now taken already has.
No.
Okay, sir.
And we have, earlier occasion, we have written notes of
Learned advocates representing
Mhm.
56.
I pay for the rest.
Developer CRP. Thereafter, you have to that is the thereafter page 29 and 30, the article 1 and 2. These are the
Page?
Page 29. The content of the charge was that I left the residential barracks without any permission from the authority. But before that, I have made a several requests to the commandant to give a leave while I was in my service. That point of time, my wife and child was they were very serious. So that several applications we made for leave, that has been turned over by the commandant. All of a sudden, I have to leave. But when I leave, I have been translated the article from the article the same and detail of the article 2, the chance to the same and detail. Ultimately, Lordship, I have been punished under section 11 of 1 of the CRP of that rate 27, which says that they have reduced my basic pay and the salary increment for the 5 years. But all of a sudden, I was not been informed. I have been transferred again to Jammu Kashmir from Durgapur to Jammu Kashmir. All of a sudden, when I came to know in the month of April of 2018, when the order was passed and my salary has been, I made an application. I went to them also to my higher authority. They refused to give us. Then I made a several RTI application. Ultimately, in the year of 2020, I have been served the final order and the inquiry report, which has been passed by the officer. So, my statutory period for filing an appeal also has not been. I have not covered that. So, in the year 2020, I filed this application. But I'm praying for just to give an opportunity to file an appeal against this order because I have not given an opportunity to cross-examine. I have not given an opportunity to file an appeal also. Doctor will kindly see.
So that in any case you could have done.
He didn't participate, Lordship. He refused at each stage. Anyway, but that he could have always done.
That he
There
could
was
have
no
always
bar
done.
filing the appeal.
What is the issue?
Throughout, he's gone through. I mean, he's been he has not accepted the copies, he has not accepted. That was his conduct throughout. He's been non-cooperative throughout. So that is what after the punishment he could have, I mean.
What was the punishment imposed? Increment was
reduction of
curtailed.
pay, reduction of pay by 4 stages for 4 years. So that he could have. I mean, filing an appeal, Lordship, and that was after he received the order, he could have filed the appeal.
Yeah.
Whenever he got the order.
So what does he mean to say that inquiry proceedings was not initiated?
Whatever he says, he could have, I mean, he could have whatever.
If you had been
grievances-
aggrieved by the order, you could have in any case filed an
whatever
appeal if you
grievances
really
he
want to
had,
do
he could
that.
have gone to the appellate authority.
I have not been served the inquiry report and the final
No,
order.
no,
I-
no.
It has been served after 2 years while passing of this final order. So I could not able to file an appeal. One. Secondly, till late, in the month of April 2018, the order was passed. For 5 years, my salary will be reduced. Increment will be stopped. But till date, my grade pay, the salary and increment has been reduced. Till date. So we are right now in 2025.
What is he saying, madam?
That is something, that is something.
What is the prayer in your writ petition?
He had challenged the final order and the
So he has challenged the final order.
final order.
So now you want to
But soon after I've been served the final order, I immediately file this application. This is 3 years ago.
madam, I'll fix for orders.
Not
For the submission of learned advocates representing both the parties. Next date be fixed on 9th of September for orders. Next. 57.
For the respondents, well, today the writ petitioners should file their reply.
Reply is ready, Lordship. I am handing over to my learned friends. And the reply.
Your
Lordship can be fixed to date for hearing. Any date as per your Lordship.
affidavit and reply filed by the learned advocate representing the petitioner, serving a copy of the same upon the learned advocate representing the respondent, be kept on record. The readings are completed. Now, next date be fixed on 17th of September.
Written. Grateful.
কোনটা পাস ওভার ছিল?
31. 31. I have a very bad case to begin with. 2 persons, both of BSF, were charge sheeted and were proceeded on the basis of a similar offense. They had allegedly smuggled some quantity of sugar from this side of the border to that side. But during the course of PCSC charge, it was found that already transpired that both have accepted the guilt.
Accepted
the guilt. One person came up before this court, writ petition dismissed, thereafter went up to the division bench. Division bench directed the central government agencies that he be reinstated in service with all backlash. But the central government then went up to the Supreme Court. Supreme Court dismissed his service and removed himself from service.
So the position remains arising out of the same offense, one person or service has been terminated. This is the other person. I came up before your lordship, single leg. There was no interim order. I am out of service now. My only point of difference seeking before your lordship that this person is hailing from Kerala. This person doesn't understand Hindi properly. The entire admission of guilt is on the basis of one question. आप समझते हो क्या लिखा है? Do you agree? That is in Hindi. He says, हाँ, that is written in Hindi. And this is my only contention that he probably was not able to understand what is being said to him and what he ultimately agreed. This is the only point on which my petition stands. If your lordship is gracious enough to only entertain that part and
They were convicted
No.
of the criminal proceedings. There was no criminal.
Only
CCST trial
only
was
CCST
taken up.
trial, disciplinary proceeding, both terminated.
So
One has
apart from that issue, what are the other?
They had accepted the guilt. On the basis of their acceptance, they were. It was held that they have committed the crime and termination was.
So this is your subsequent thought to interpret him to be a Keralite who doesn't understand Hindi.
He is from Kerala, and his contention only is that he doesn't understand properly. Doesn't understand. This is the only.
So this is your innovative idea.
This is the only point which I can canvass before your lordship. Rest has been set at rest by the Supreme Court. I cannot even reopen.
So do you also be at rest?
I will reserve this for judgment.
No, maybe I'll keep it for orders. Why?
As your lordship.
Heard the submission of learned advocates representing both the parties. Next date be fixed on 11th of September for orders.
If your lordship has any query, kindly put it to us. We shall. Okay. Then he was
এই এখানে কে গল্প করছে? Yes, sir.
Name of the appeal. The name of the appellant was O'Neill Das alias Lalu Das. This alias Lalu Das will be.
Who is your other side? Ashok. The learned advocate representing the appellant claimant submitted to have filed an application being Can 1 of 2024, which interiorly stated that the name of the appellant, he's a sole appellant. appellant.
Also address.
Huh?
Also address should be. As per
কি বললাম?
business stated that the applicant.
Name of the sole appellant as mentioned. Sir, will you please? As mentioned in the Aadhaar card and PAN card marked as Annexure A and B respectively appeared to be Anil Dash. Anil Dash, being son of Vishun Dev Das. Now, what is the issue with the address?
Address when this file this appeal, when resides in Calcutta, the address of Calcutta will be
huh?
The address of Calcutta and Bihar also is fine. But the Calcutta address will be of this appeal. Well,
Address will be as it is. I'll just change the name. The address is appearing in the claim application? Yes. Address is appearing in the claim application? Let the address be as it is. Only the name. क्या बोला? Bishun Dev Das. Achha. However, the claim application mentioned the name of the present appellant to be Anil Das alias Lalu Das. No, করা যাবে না এটা. You see, this is the LTI of Anil Das. Now, who will identify? There is no identification also. Whether he's the same person or not. And you are seeking for change of address also. The LTI of Anil Das. You file a proper affidavit. Nothing.
At the time of filing the claim application, he put it in the LTI.
Sir, there is no identification. Nobody has identified. You have written by the pen of. Cut off. Anyway, who will file the paper book?
Paper book is
Can it be disposed of or you need further hearing?
It can be disposed of, Your Lordship. It can be paper book filed.
I will not accept, I will not consider your CAN application. It's full of flaws. The next date we fixed on 18th of November for audits. Paper book filed by the learned advocate representing the appellant claimant we kept on record. Next.
Deeply obliged.
much.
Yes.
Huh?
There is 76 days delay. The fact of the case is that one or two applications.
You had to remove certain defects. Have you done it? Remove korbar chilo na defect? Your CAN application is not with the SR section.
Yes, madam.
They've stated that it had been sent to the courtroom number 16.
I have the CAN application, CAN 2, 2024. That is
CAN 2 of 2024.
CAN 2 of 2024. That is the application for section.
ওই ডিপার্টমেন্টই প্লেস করুক চঞ্চল
Milord, I really do not stand in due of Section 5. I may not submit anything.
application has to be on record first.
Yes, Milord, and even that has not been served on us. Section 5, I do not stand, Milord. That should
Now,
have
who
been
is the
served.
section officer? এটা কে?
And what is one?
হ্যাঁ?
One টা কি
ও একটা
করেছে?
রিপোর্ট দিয়ে দিয়েছে সেকশন অফিস।
Order কি আছে? এটা কি করে পেতে দেবে? Clear the appeal. ঠিক আছে।
So you come at 2 p.m.
Milord, as to this application, Milord,
You come at 2 p.m.
Lordship, I will,
এদিকে
Milord, there is other,
সেকশনে কে আছে না
if you,
এস দে যে সই করেছে তাকে ডেকে পাঠাও।
if your Lordship makes it tomorrow, Milord, because one matter is fixed in court note number 8. Which
You may not be present. You may ask any of your junior to be present.
ঠিক আছে, if I can, Milord, I will. Otherwise, Milord, my junior.
ওই যে যে সই করেছে না
The insurance appeal, issue has remained absolute. My development note was to file this.
No, I will file the paper book on Monday, my lord. Paper book is being made ready, my lord.
রেকর্ডটা দেখি। You only asked the matter to be fixed.
Yes, my lord. Due to my personal difficulty, I could not prepare the paper book, but today I have prepared. Paper book is being made
The
ready.
paper book comprises of only those
Only in being ready.
but you are showing those index
Hello.
papers as your paper book.
On Monday.
On the prayer of learned advocate representing the respondent claimants, let the matter be fixed on 18th of August for filing paper book as last chance.
Yes, my lord.
Next.
Wherein I had taken the ground of contributory negligence, income, and that extra amount on consortium.
Yes.
My lord, regarding contributory negligence, my lord, the eyewitness stated that the due to accident took place due to negligent act of the my lord the offending vehicle. Though my lord offending vehicle was in front of the victim vehicle, my lord actually the offending vehicle overtook the victim vehicle at the relevant point of time, and thereafter my lord turned into the left side. without indicating anything.
My
So,
lord
my lord,
will
accident took place.
my lord will kindly come to the first information report, my lord. It is at page 34 onwards. The first information report, my lord.
Page 34.
34. 34. The relevant page is at page 38, my lord. The last but 3 lines, my lord, from there. হঠাৎ সামনে থাকা এটা কি সম্মুখী কি এটা একটি হঠাৎ সামনে থাকা একটি 10 চাকার গাড়ি সমমুখী একটি 10 চাকা গাড়ি যার নাম্বার WB29B1443 দ্রুত বেপরোয়া ভাবে যেতে যেতে ব্রেক মারলে এই চ্যাসিস গাড়ি 10 চাকার গাড়িকে পিছন থেকে কি লেখা রে বাবা পিছন লেগে যায় ফলে আমার বাবা গাড়ি this is the FIR of the first of the by the son of the deceased, my lord. Now this fact has been affirmed in the charge sheet as well. Its fact remains that the victim vehicle was at the back and the truck was going, my insurance company's truck, it was going in front. The speed at which, when I am at the back of a vehicle, I am equally responsible, my lord, because I can always adjust my speed. That much leverage has to be there. At any point of time when I am on road, the vehicle in front can apply the brake. That is always there. I being at the back, I have to be careful. I have to maintain a certain distance. That was not done in this case. So contributory negligence on my part, it has to be there. The judgments I've given in my written notes, my lord will kindly see. My lord will kindly come to page 3, my lord. Page 6, my lord will kindly come to. This is Lachoram. 2014-13 Supreme Court cases, page 253, Lachoram versus Himachal Road Transport Corporation. In this case, my lord, I'll just go to the head note, my lord. Mere involvement of a vehicle in accident, page 6, my lord, held cannot fasten liability to pay compensation unless rash and negligent act of driver can be proved. On facts held, since bus was standing at red light and could stop within 100 to 150 yards of traffic signal on being asked, it cannot be said that the bus started at high speed. Besides, PW2 was a reliable, that's the eyewitness. So in this case, my lord will kindly come to page 8 now, paragraph 10. In this case, the bus was in front and the deceased motorcyclist was at the back. That, my lord, will find from paragraph 10, my lord, page 8. Has my lord found it? But simply the involvement of a bus in the accident cannot make the respondent liable to pay compensation unless it can be held on the basis of materials on record that the accident was caused by rash and negligent act of the driver, respondent number 2. On this issue, on comparing the reasons given by the tribunal while discussing issue number 1 and those given by the High Court on page 10 and 11 of the paper book, we find the reasons given by High Court to be much more cogent and acceptable in coming to the conclusion noted above. Since the bus was standing at the red light and on being asked, soon after starting from the traffic signal, it stopped within 100 to 150 yards. It had rightly been reasoned that the bus could not have started on a high speed. The road at the place of accident was admittedly very narrow, and PW2, who had been found reliable by the tribunal as well as the High Court, was present on the spot, has not claimed that the bus driver had given a signal to the deceased motorcyclist to overtake him. This witness could not see the actual accident because at the time the motorcyclist, in an effort to overtake the bus, had gone on its right side and was not visible, and therefore he could only hear the sound of crash. So what I'm trying to say, my lord, the responsibility of the person who's at the back, who's behind the vehicle in front, the responsibility, it is always there. It is also there with that person to drive the vehicle carefully. My vehicle is definitely is also responsible for the accident. I do not know what happened, why my vehicle applied brake. Maybe something was there in front, that's why he applied brake, but no evidence is there. But when the victim was at the back, it's his responsibility also equally. He should have also taken care, my lord, so that the accident did not take place. This is my ground on regarding contributory negligence. My lord, I've given also two more judgments, my lord. That is one is at.
Yes, I've seen.
My lord. Now, regarding the income, my lord, it has not been proved. It was only on oral evidence. It's an accident of 2018, and the income was taken to be 12,000 per month, only on the basis of oral evidence, considering that the victim was a driver. He was driving at that time. So that is one ground. I pray that my lord will kindly reduce that. And lastly, that spousal consortium, 50,000 extra was granted. The total amount should have been restricted to 77,000.
And my lord, in this case, my lord, kindly see, my lord.
I'm sorry.
My lord, the justice will find page 5, my lord, the case of the my lord claimant. The case of the claimant, kindly see, my lord, regarding contributory negligence. That on such and such day at about 10 a.m. near Bitsipur flyover bridge over NH6 road under PS Uluberia, district Howrah, while the victim deceased was proceeding towards Kolkata from Kharagpur by driving the non-offending vehicle such and such number by keeping the same in the extreme left side of the road, as well as also after keeping the same in the safe distance from the offending vehicle such and such, which was also proceeding towards the same direction. Suddenly, the said offending vehicle came with excessive high speed from behind, rashly and negligently overtook the vehicle of the victim deceased and turned into the left side of the road without giving any indication and applied brake after violating the road traffic rules, for which the non-offending vehicle of the victim deceased dashed behind the offending vehicle such and such. My lord, this is the fact, and that fact has been proved by PW2. And in the charge sheet also, my lord, your lordship will find from the charge sheet, my lord, the charge sheet has been given against the offending vehicle. And my lord, in a similar situation, in my written argument, your lordship will find the Momta and others versus Bhav Singh, my lord, reported in 2002 4 TSE 746. In a similar situation, my lord, the offending vehicle has been held by the vehicle, my lord, who applied the brake in front. In a similar situation, in that case, my lord, the offending vehicle has been, my lord,
okay,
my lord. And my lord, regarding income, my lord, the victims, my lord, the driving license has been exhibited. Victim driving license has been exhibited. 2018, my lord, 12,000 has been, my lord, taken. That is, my lord, correct. And in a similar situation, the Honorable Appeals Court, in a similar situation, taken, my lord, 20,000. Here, my lord, 12,000 has been taken.
Written notes filed by the learned advocate representing the appellant insurance company. We kept on record on the submission of the learned advocate representing the respective parties. Next date be fixed on 11th of November for orders.
My lord.
Grateful, my lord.
November,
What about Mr. Ashik Mondal?
Milord, he has not been coming, Milord. This is fixed today for filing of paper books, Milord. It was yesterday as well. But I have been informed Mr. Bandyopadhyay would be filing paper book on behalf of Mr. Mondal in this case, Milord.
Sure. Paper book filed by the learned advocate representing the respondent claimants be kept on record. Can it be disposed of, Mr. Singh?
Lord, it is mainly on quantum, Lord. An award of 1 crore 60 lakh has been passed. Lord, 30 lakhs has been paid to the claimant by my lords, by this honorable court's order, Lord. That's mainly on quantum, Lord. One loss of one limb, 100% loss of earning capacity assessed, Lord, on that basis, Lord.
So I'll fix for orders.
Lord, I'll be taking some time of your lordship, Lord, because it's a huge amount, and Lord, I'll be on the loss of Lord earning capacity.
Now, when will he come?
My lord, at your place, my lord,
He will come as I ask him to come.
my lord, as I am informed, my lord, he is from Monday. He may be available, my lord.
Next date be fixed on 27th of August. Let him come at least.
Deeply obliged. And my lord, one
Then I'll
intelligence, my lord, let the copies of the paper books are maybe recorded, my lord. Copy of
Next.
Grateful to your lordship.
My lord, 81, my lord, I am praying for not today on behalf of Shamal Kumar Mukherjee, appearing for the petitioners.
See? Isha. None appear to represent the appellants. আচ্ছা এটার 5th May অর্ডারটা কত কোথায়? এর 5th May লিস্টে ছিল না? None appear to represent the appellant. On the earlier occasion also, the learned advocate representing the appellant Union of India sought for time. Let the matter go out of the list. Next.
My lord, I am for the respondent 81.
What are you saying?
Yes, I was in the court, my lord.
At number
Which matter?
Yes, 81.
I have asked it to go out of the list because they are not appearing. They are not even interested to move the matter. They file and they keep it pending. Next.
Lordship, 82, Mr. Anandagopal Mukherjee appearing for the ordinary instrument. 2 p.m. Lordship, Justice requested me to take some adjournment, but his court number another court. Justice requested me. I'm
86.
Yes, ma'am.
In this case, I am
I am for the I am for the appellant, my lord. Insurance company. But I have filed the appeal mainly on 3 grounds, my lord. One is, my lord, 12,000 rupees has been considered as monthly income when there was no proof of income. And accident took place in the year 2016. And my lord, loss of consortium has been allowed as 2,20,000 to all the 4 claimants instead of 40,000.
Now your stay had been made absolute. Hey.
Stay was granted, my lord.
Poka bites.
purely quantum, my lord.
Your stay was made absolute.
But right at this moment, my lord,
I have, there's no noting. You have only filed the statutory amount. I mean, the challan with respect to this statutory amount that you have deposited.
On 23rd June, my lord, matter was active 23rd June.
তো 25 Yes, sir. Where is the copy of your challan?
my lord, unfortunately, my lord, I have today I have brought only, my lord, I thought, my lord, it will be hard. Today I have brought only, my lord, the paper book.
State absolute color. You file the copy of the challan. File the copy of the challan and the next date. You have filed the paper book.
Today I have filed paper book.
The paper state absolute color. Paper book filed by the learned advocate representing the respondent claimant be kept on record. Yes.
I have already, my lord, the purely quantum, my lord. Insurance company raised the issue that no document has been filed. But regarding, my lord, business, automobile business document has been filed.
It can be disposed of.
Next date heard the submission of learned advocates representing both the parties. Next date be fixed on 13th of November for orders. Okay. The learned advocate representing the appellant insurance company is to file the challan with regard to the balance amount of the compensation granted by the learned tribunal on the next date of hearing.
Well, today I am supposed to file the opposition, my lord. কপি কোথায় গেল? এতক্ষণ দেখুন কপিটা কোথায়? ঠিকঠাক কোথায় গেল? অপোজিশনের কপিটা কোথায়?
Yes, sir.
Yes, my lord.
You did not get any other convenience.
Position, my lord. May I file?
My lord, for that opposition, I have to file a reply. For that,
What is the issue here, sir?
My lord, this
classification because
misdeclaration with bringing the iodized salt from outside, your lord.
my lord, for that opposition, I have to file reply.
So when this is that matter, when
Yes.
a battery of lawyers came
Yes.
for that bail issue.
Yes.
And now, once that issue is over,
No, my lord, all are
Now they are enjoying.
interim protection.
They have deposited the amount with the register of appellate site.
Yes, my lord. And then, my lord, today is expiring the interim order. Kindly extend this interim order, my lord.
বলবি তো
the affidavit in opposition filed
জানাবি তো
by
এর
the
নামটা
learned advocate representing the
না না বললে হবে
respondent number 1 to 5 be kept on record.
অ্যালাউ করে না এই জানি যে এইটাতে লিখে দিয়ে দিই
Where's your application for
My lord,
grant of
it's today expiring today, my lord, 30th August 2025. Thank you. My lord, now kindly have a look into the order dated 15 July 2025, my lord, where it is stated that the interim order granted earlier be extended till 13th August
Yes.
2025. My lord. For that, today is expiring just.
affidavit and reply, if any, to the aforesaid affidavit in opposition is to be filed by 29th of August.
29th of August.
Interim order granted earlier be extended till 29th of August. Next.
Great photo. Perfect, thank you. Fine.
Lordship, this is my appeal. On last occasion, my stay has been made absolute, and there's a direction upon the registrar to serve upon them for their appearance.
Your Lordship, and for the respondent claimants.
Have you filed your? You have not deposited the statutory amount.
Your Lordship, the entire amount has been stayed, Your Lordship. Your Lordship, my challan receipt is.
Huh? না নাকি এইখানে নোট আছে।
Lordship, kindly come to the last order, Your Lordship.
Okay. No, it's there.
Yes, sir.
এই আদিত্য ওর You have filed the affidavit of service?
Yes, sir. Last occasion we have filed. It is noted in the order sheet, Your Lordship. Paper book finding, order finding.
Who is appearing for the respondent? Have you filed the Vakalatnama?
Lordship, check whether it's.
You have to check whether you have filed the the learned advocate representing the appellant insurance company is present. None appeared to represent the respondent claimants. The register administration LOM is directed to serve notice upon the respondent claimants to the concerned police station, intimating the next date of hearing and file a compliance report to that effect. Next date. Which district is it?
South 24 Perkins.
You are
South
tagging with the 3rd of September.
I am appearing on behalf of the appellant insurance company. This is the challan I've already deposited, but the affidavit of service I could not prepare because the track report, I believe there's some error in the website of India Post because it says article not booked, but I have served. So on the next date, I believe they will be doing something. I'll send my man to inquire what is the difficulty. I've taken the printout also of that page, which
You
says,
want the state to be made
my
absolute?
lord, my lord.
State to be made absolute. Next date
And
we fix on 3rd of September.
my lord will kindly also.
Affidavit of service.
My lord, I will also. Acha, my lord. On that day, my lord will call for the TC. My lord, grateful.
Next.
106 also, it's the same issue. One Mr. Shirajul Islam is appearing on behalf of the claimants. This is my challan. I want my stay to be absolute.
No, where is that? Where is he?
Your Lordship, today I have filed the Vakalatnama.
I have
On this, in this matter.
I've checked the net, internet, my lord, the website. They have filed the vaka, but where is he? I do not know, but he has filed the Vakalatnama. Mr. Shirajul Islam.
But if that be the case, he's not there in the
No.
court.
No.
None appear to represent the respondent claimant. So same order.
My lord.
Your state to be made
My
up.
lord, my lord.
Which district?
This is South 24 Parganas.
Same order.
My lord, grateful, my lord.
Let the administrative notice be
My
there.
lord, my lord. 3rd of September, this also. My lord.
Next.
Grateful, my lord.
Lord, 107 is insurance appeal.
Lord, I was praying for the stay to be made absolute pursuant to my Lord's direction. Lord, the entire audit sum has been deposited. My Lord is appearing on behalf of the claimant.
He was there on the earlier date.
No, my Lord.
Have you filed the wakalatnama?
Yes, yes, Lordship. I have filed Vakalatnama. Yes, Lordship, that I have filed.
Acha, who will prepare the paper book?
Lordship, I have already prepared the paper book. In this case, mostly, Lordship, the appeal prepared by the insurance company in earlier occasion. Before the
File the paper book?
Yes.
Paper book filed by the learned advocate representing the respondent claimant be kept on record. Next date be fixed on 14th of November for further hearing.
Lordship.
11th 8 I have filed.
Oh,
14th November.
Maybe orders, Lordship.
None of you said for orders.
Lordship, we are humble submission also make for orders because of Lordship is the only quantum is not the
It is the insurance company's appeal. How can you say it can be fixed for orders?
The insurance company appeal prior to the filing of this appeal, they have prepared an appeal. After hearing the appeal, our Honorable High Court send the remand back the matter for de novo hearing. Against the de novo hearing, the my clients prepare an appeal to the Supreme Court. The Supreme Court also allowed affirm this order of the Honorable High Court. In view of that, the de novo hearing done, and the learned tribunal passed the same order, but they have also passed the same plea. But they did not, under the impression, they will adduce some evidence in support of their case that vehicle loss is involved. But Lordship, they did not adduce any evidence except one of the evidence that is their own investigator.
Can it be fixed for orders?
Lord, I'll make submission. Lord, you want to fix it up.
You will make.
Ajay, for orders.
I am okay.
One thing,
Huh?
I prefer the respond this matter. Petitioner, madam. তুমি এদিকে এসো। যাও যাও। My lord, the petition of your lordship, my lord, is a government of India enterprise. That is the BSNL, my lord. My lord, who entered into an agreement with some contractor for the purpose of execution of various work. My lord, I have already annexed such kind of agreement from where is transpired, my lord, that I used to give work to the contractor who is to do work for the BSNL. BSNL does not take employees from the outside. My lord, in terms of clause 5, 10, 12, 21 and 25 of the sample agreement, which is page 237 at P15, my lord will find that accent to the কাগজ ফোন করার টাইম পায় না, এখনই ফোন করতে পারবে। P37 my lord will find volume 2 of the supplementary affidavit.
Which page?
My lord, page 237, my lord. I would like to kindly come to my lord, page 238, bottom, my lord, 5. The contractor will solely maintain the job contact labors and will decide the number of workers to be engaged for execution of work. The company will not have any concern with the labors engaged by the contractor, nor will any official will supervise to the said labors. Now, my lord, kindly consider, my lord, clause 10. The contractor will obtain license under the Contract Labor within bracket Regulation and Abolition Act according to the number of laborers engaged by him by depositing the fees and complying with the formalities. He will also seek the renewal of the contract at or before the expiry of the license. Most important, my lord, 12. The contractor will ensure that he is covered under the Employees Provident Fund and Miscellaneous Provision Act and Employees State Insurance Act having its independent code number. Thus, he will ensure that all the eligible employees are covered under this act. BSNL is not covered under this act. BSNL has clarified its position, my lord. My lord, kindly come to page 241.
No, you come to page 240.
241.
You come to page 240.
240.
Clause 15.
My lord.
What does it mean?
BSNL Calcutta will not be responsible to pay any other charges or cost, compensation, damages for engagement of such person except within the ceiling of rate specified by the competent authority of BSNL Calcutta Telephones from time to time and claim for payment of bonus, gratuity or any other to the persons engaged by the contractor. Engaged by the contractor.
Contractor is an immediate employer and he is a principal employer.
Or any other to the persons engaged by the contractor for job contract will not be considered by BSNL.
Yes.
My lord,
Calcutta Telephones as per this
let him
contract
finish, my
is-
lord, then I will make my submission.
Yes. Then which page?
Page 241, point number 21, my lord.
Yes.
Contractor shall submit the list of contract worker deployed by it to the company, and at the start of the contract, and this list will indicate their names, addresses, and date of joining with the contractor, within bracket, date of EPF introduction, and any movement within the control workers thereon will be intimated to the company from time to time. Now, my lord, the last point is, my lord, point number 25. Page 243. Relevant point, my lord. That the company will pay to the contractor for the work which the contractor called upon and which has satisfactorily done in accordance with the tender document at the rates as mentioned in the work order within 30 days from the submission of bills. For this purpose, the contractor should submit his or her bill to the concerned authority as quoted rate in work order within 30 days after completion of the month. Until and unless, my lord, he complied under the ASI Act, he has his separate code, he satisfied the BSNL, my lord, BSNL is not going to pay a single penny. I have documents to show that they have already paid their part. Now, what happened, my lord? Initially, I must put in this fashion, my lord, that the initial writ as well as the instant writ before lordship, my lord, is the outcome of a compulsion. The respondent ESI is not accepting its defect, rather it is converted the same into an ego issue, my lord. The initial writ was against a garnishing order whereby obstructing the bank from financial transaction, my lord, against which I preferred before this Honorable High Court. The then Lordship direct us to clarify the same before the ASI. We have gone there, we have shown all our documents, tried our level best to satisfy them, but they are stubborn. Now, before I am going further, my lord, I would also like to say, my lord, BSNL doesn't fall under the purview of ESI, my lord. The Act says so, my lord. একটু বই আছে যশোর কাছে এমপ্লয়ি স্টেটেশন দেখুন না একটু কোন কোন সেকশন আমার কাছে তো বই একটাই গো
দাও না যশোরকে দাও আমার কাছে নেই
হ্যাঁ দিচ্ছি তুমি ফোনে খোলো তুই এর কোনটা বললে ইনফ্লুয়েন্স করো my lord kindly consider 9 2 subsection 9 definition of employees, my lord.
Yes.
BSNL does not fall under any of these three clauses, my lord. Who is directly employed by the principal employer or any work of the incidental or preliminary to the connected with the work of the factory or establishment. This is not a factory, not an establishment. Whether such work is done by the employee in the factory or establishment or elsewhere. 2 is, my lord, who is employed by or through an immediate employer on the premises of the factory or the establishment or under supervision of the principal employer or his agent. BSNL also does follow this, my lord. Then, my lord, whose service are temporary lent or let on hire to the principal employer by the person with whom the person whose service are so lent or let on hire has entered into a contract of service, my lord.
Now, how will you expand this scope? 9.2, who is employed by or through an immediate employer? So, who would be An immediate employer. BSNL would not be an employer.
The contractor who has the ESI code, my lord. I do not have a ESI code. They wrongfully generated an ESI code. I have never applied for ESI code because I don't fall under this act. They wrongfully generate one ESI code. They claim that I shall pay my requisite under ESI code. My policy is, my lord, ESI code after they have paid the requisite under the ESI code, the contractor, I reimburse, my lord. I reimburse. The challan which they produce before the BSNL, my lord, I reimburse them on the satisfaction that ESI code is there and accordingly ESI payment has been made by the contractor. And already
a bill where you pay such amount.
Supplementary transfer. Page 6. বলেছিলাম আমাকে করে রাখতে পেমেন্ট করেছি আমি ওই চালানটা চাইছি চালানটা এরকম করে কেউ কোর্ট আসে না ভাই
You have to show a bill or a
I shall,
challan, whatever it is, that
shall.
you pay them that amount. I mean, it's inclusive in the contractor's
certainly,
bill to be paid towards the services rendered by the contact laborers. So you come back on the next date, you flag the pages and then come. Ashwin.
My lord, one respectful submission.
Yes.
My learned friend is saying, my lord, they are not covered. Other units of BSNL are still complying, but accepting this because, my lord, this matters second round of litigation. For if your lordship kindly takes, my lord, the order passed by justice, sir.
Next date.
Yes, on that. My lord, they have already paid, and my lord, this is a contractual employee, my lord. We are not harping
So if you have other
yes
institutions or whatever you have said,
BSNL, other units.
Yes, other units to have engaged the contract laborers through
This is the system of the BSNL, my lord. I can produce that.
Through contractors. They are saying the contractors are the immediate employers, not the BSNL. So if similarly you can state or you can cite examples where in the similar set of affairs, where there's BSNL, there's a contractor in between and also contract laborers, BSNL has paid. You show me such documents.
I will come, my lord. Yes. I will. I have also mentioned, my lord, in my
The submission of learned advocates representing both the parties. Next date be fixed on 2nd of September. In the meantime, sir, you flag and you mark and then you get those challans where you can show that you have paid that amount.
My lord. And also, my lord,
contractors.
And also, I will take a plea, my lord, that there is a provision of appeal under section 75 of the Act where he can raise all the disputes, whatever he has. That is the EI court, my lord. EI, my lord, Employees Insurance Court is the, my lord, the authority where, my lord, all the disputes can be, my lord, settled. And I can show, my lord, on that day.
Next.
Can I
Sir, I have dictated the order. Next. That's why I told you, just flag the pages.
Flag, my lord, it's my mistake. I failed to page 132, my lord.
2nd
September. 2nd September.
They appear for the bank lordship. Lordship, as per your lordship, solemn directions, lordship, we have already lordship filed notes of argument, lordship, and last occasion lordship's desires, if any difficulty will arise, lordship failed from your lordship will consider that, lordship. And there is recent judgment already pronounced by this honorable court, as well as single bench, as well as the honorable division bench, lordship, same bank, lordship, where lordship both of us appeared on behalf of the bank lordship, and in respect of that two persons lordship, they are also discharging their duties lordship as officers. And the present writ petitioner lordship, he is also officer.
So where are the copies of those?
Copies of the notes of argument already filed lordship, earlier occasions lordship. We have already exchanged.
Lord, this issue on these those two judgment which my learned friend is Lord, relied upon something. My case before your lordship, as I have argued, my lord, the evidence which was laid before the disciplinary authority and found by the appellate authority, it was not properly appreciated. The evidence says otherwise. The finding was otherwise. So, my lord, the judgment on the fact that the court will not enter into, my lord, the disputed question, my lord, but I have, my lord, also relied upon the Supreme Court judgment where it says, my lord, when the court found that the evidence has not been properly appreciated, the writ court is justified, my lord, the entering into, my lord, and appreciate the evidence, and then, my lord, consider, my lord, the situation. Because what has happened, this petitioner before your lordships was
the charges in this writ petition. Let me first finish. The charges against the petitioner in this writ petition, whether they are similar to the charges in the writ petition against which the judgment has
No,
been
this is the
pronounced.
principle is involved. Principle is involved. This is principle is involved.
What principle?
Whatever because I was there in both the matters, and this was the principle. What should be the effectiveness on this position? So that's why this has to be taken into consideration. Whether you have
What, sir, please?
My lord, what I'm
Tell me once again.
I am telling that it is the situation that we have explained before your lordship by different judgments. So this comes into the same footing. That's how I'm telling, same footing. How far the court can go into this position in the question.
You are on the law point on reappreciation of evidence via writ court. I am asking you whether the charges against the instant petitioners are similar to the earlier charges.
Almost lordship similar in nature lordship, because as per the officers regulations lordship, the clause is referred to almost
those officers
lordship.
were of the same designation as the present petitioners.
They are the manager lordship, and here he is also manager.
It's not a manager.
But, whether the charges are same.
Charges are almost same lordship, because as per this represent concern lordship, he has not discharged his duties as per
Since you are relying on the judgment,
lordship.
that is why I am asking you.
Lordship. But the principle is the same, lordship. Whether the sophisticated rules of evidence was followed or not, lordship, that the judgment of the honorable apex court that has been followed, lordship. Whether the writ court can interfere with the decisions of the disciplinary proceeding, whether the writ court can act as an appellate authority over the disciplinary proceedings, this has been already considered, lordship, by the both of our lordship honorable court division bench as well as the honorable
He says if there are anomalies or arbitrariness in the process, then the writ court can, to certain extent, reappreciate evidence. This is what your stance is?
Yes. And, my lord, subject to correction, my lord, the judgment, what my learned friend has relied upon, these are factually different, my lord.
So that is
He's
not
saying manager. The petitioner before your lordship was not the manager only. He was the general manager, Southern region.
That doesn't.
So, my lord, how then loan, how it is processed? It is goes before, my lord, for the first time to the branch. The branch officer first, my lord, examine the documents and then forward it to the next level as a senior manager. From there, my lord, the officer is earmarked for conducting, my lord, all scrutiny and field verification. After that, it goes to, my lord, the deputy general manager. Deputy general manager thereafter recommend the loan whether it should be processed or not. If it is recommended that be processed, then it goes to, my lord, the senior level credit committee, which comprises of 4 manager level. If they say yes, it can be processed, then it goes to me, that the petitioner before your lordship, who is the highest authority. And, my lord, here, my lord, the allegations are such that why you have not gone to the field verification. A general manager of Southern Region is not supposed to go for the field verification. He's completely relying upon whatever the document has been placed before it. And, my lord, you'll see I have given in my written notes.
So you mean to say the charge was framed only against the general manager?
No, my lord. There are other persons are involved, but none of them were dismissed from service safety. 7 except this petitioner, one person.
My lord, he is the superior of that branch, lordship.
Therefore, my lord, there are 13 persons who were charge sheeted. My lord, it is only the petitioner and one other person was dismissed from service.
You say that they were
charge sheeted according to the hierarchy?
Milord, they dealt with according to the hierarchy. The highest officer was given the highest punishment, and the lowest officer were not one, 2 or 3 increment. One was of them was retired, therefore not charge sheeted. So, the entire charge sheet, if your lordship sees, it depends on why the lower authority has not actually taken steps. Not as a general manager of Southern region, you are supposed to, look into the document and then proceed. And even their board of director has approved that there is no problem in the loan. After that the person has defaulted in paying the EMIs, and then they suddenly come up and says, no, it is because of your fault, entire loan has become NPA. That is what they have run in the charge sheet. And what they are saying, their own document which they have laid in evidence, they have completely misread those documents. While granting the loan, they have treated it as an MSME, the companies to whom the loans were given. But while the deciding the charges, they are treating as large sector employee, which is contrary to their own rules. My case is what my learned friend is saying on law point. I have no quarrel. My only case is that my lord can enter into the fact when my lord will be manifest that there are anomalies in the evidence and that evidence has not been properly appreciated. If High Court doesn't intervene, and that is what even the Supreme Court says. My lord, that is I have annexed. The Supreme...
Okay, sir.
And lordship, so many judgment lordship already lordship annexed to this lordship. Notes of argument lordship, all are the honorable apex court lordship.
Okay.
And that has been relied by the division bench as well as our single bench lordship in respect of the all are the officers category. And regarding it as per
the highest officer.
And he is the highest officer of that branch lordship. And
from the branch region.
From your lordship's queries lordship, this particular person's lordship, according in comparison with the other 2 persons lordship, charge is so grievous. Because crores of money has been involved, and he has been passed that.
And
on his own whims.
That was the villain even approved by as per their evidence.
And
that was even approved by their higher authority, even my higher authority.
Hearing concluded. Next. আচ্ছা আপনাদের দুটোই ছিল হ্যাঁ ঠিক আছে প্যাপেলেট সেট এই
item number 14.
Lord, I'm for CSTC, my lord.
না 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 আগে পাস ওভার গুলো 2 PM যে পাস ওভার আমি বলেছিলাম স্টেটের কাউকে ডাক
On the last occasion, my lord, the learned GP appeared and he had assured the court that Nilotpal, Advocate Nilotpal will be assisting this court and appear on behalf of the state, my lord.
Item number 14.
Because this is a matter, my lord, where with regard to the appointment of the people, we can't do anything because state has to take a stand.
Appointment.
The report has also been reaffirmed and filed, my lord, on behalf of CSTC.
Which Chatterjee? But ask him to come.
Yes, yes.
So you can be online or you can join later on, but you ask him to come.
Yes, yes.
Much obliged.
So you please wait. Today, let us resolve this issue. Oh, of who will appear?
At 23, my lord, I am appearing for the petitioner. The last occasion, the I have already submitted that I have already retired from my service. But so far the pensions, area pensions and other benefits has been withheld. Some things, my lord, amount of 7 lakhs has been, my lord, released, that in which I have already received. But so far the facts and circumstances of the case, whereas the, my lord, this court has been directed to the authority concerns to inquire into the matter regarding the certainty of this of his unauthorized absent. Now the unauthorized absence, the issue was, well, inquiry officer was issued this notice. I appeared. Ultimately, it has been gone to the disciplinary authority by my lord, passing this order, and I have been, my lord, that demotions of my post. And on the basis of the demotional post, there was in a directions of that court that this is not a, my lord, disciplinary authority or any actions has been taken against the petitioner. Only to inquire for a certainty of that last unauthorized absent of 716. Now the 716 my lord, inquiry officer has to be, my lord, inquired and ascertain that yes, this is the right thing of 716. Whereas, my lord,
What is 760 days?
Days. Because the, my lord, the inquiry officer ought to have, my lord, perused the records and facts of the case. The petitioners was continuously, my lord, attending the office, but there is no any unauthorized absence, save and except the medical report or medical leave. Fine, my lord, there is a particularly only for 20 or 22 days. But apart from that, all on a sudden the inquiry officer has been, my lord, certainty that 716. So 716 days has been absented. That's why he has been, my lord, demotions of his post. And after that, my lord, in the month of December, he had retired. Ultimately, my lord, prior to that, my lord, he has not been given release of any pension or, my lord, any dues of the retirement benefit. And accordingly, my lord, these writ petitions, the present writ petition is kept pending before the lordships for final disposal. Because there are, my lord, third litigations. First litigation is 2004. I have been transferred from Ultanagar to Siliguri. There is no any, my lord, transfer order. Although the authority has been, my lord, transfer me on 17th February 2004. Then ultimately in 2004, one of the writ petitions, first writ petition was moved, and this court was stayed of that transfer order. Then automatically, my lord, I was stand away in the Ultanagar depots, and I have been working. Now ultimately,
Then it is that matter where you used to go, and your claim is that you were not allowed to sign the register.
Yes. My lord, your losses, my lord. My lord, grateful, my lord, your losses. Remember that, my lord, matter regarding this attendance register is separately for me. So for the other employees are concerned, their attendance registers is, my lord, the in original. Now ultimately, my lord, the separate registrations, my lord, why? That's why 716 has been absented, unauthorized absent. 7 except.
What was your job profile, sir?
My lord,
What was your job?
my lord,
What you had to
initially,
do?
my lord, initially was the, my lord, the artisan. Ultimately, my lord, 1988, re-designated as a partsman in the, my lord, North Bengal State Transport Authority. Now I have been, my lord, working in Ultanagar. Now all of a sudden in 2000, my lord, 17th February 2004, I have been transferred. That
No,
transfer
I
is
asked
totally-
you your job profile. I mean, what you used to do there? You used to go. They did not allow you to sign the register. Then you used to come back.
entirely, my lord, on and from 7 except medical leave. I have been
I'm
working.
asking you what you used to do there. You
Let-
for 716 days, that is nearly two years.
Nearly 2 years.
Nearly 2 years.
2 years
Every
above.
day you went there.
Yes.
They did not allow you to sign the register.
Yes.
So what you used to do?
Well, that's because well, the second writ petition was filed in 2006. Only directions to ascertain. That directions has been well, ultimately finality.
What you used to do there?
Well, I have done because
What have you done?
yes, well, I made an application in regard to this so-called notice and reply. No. That's I will stated everything. Well,
You went to the depot, that Ultodanga depot.
My
Right? Every day you used to go to the depot.
yes.
So once you went to that depot, the concerned people over there, they did not allow you to sign the register.
No.
Then?
But facts is this. But I have already continuous in from the date of inception, appointment of the inception. Now automatically when I have been transferred in 2004, 17th February 2004, that was state of this honorable court. That automatically I was.
We will come to that later. I'm asking you a very simple question.
Well,
You used to go to that Ultodanga depot?
yes.
You had on transfer, you had filed a writ petition, then that was stayed, then you did not have to go to Siliguri, right? Then again you went to Ultodanga?
No, Ultodanga was already existing. I have
So,
been
no,
working.
Ultodanga was existing. From Ultodanga, you went to they transferred you to Siliguri, you filed a writ petition, and thereafter you succeeded.
Yes.
Right? You did not have to go to Siliguri.
No.
So you went to Ultodanga again. So when you went to Ultodanga, what did you do there?
Automatically I am working on that.
What are you working?
Because as a partsman.
As a
partsman.
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 What you had to do there?
Continuously.
What was the nature of your job?
While partsman is yet. Oh, in regard to these vehicles to be inquired into this. Partsman is the workload. Those are in garage of that vehicle. That vehicle is to be inquired. Yes. Some of the inquiry. Parts of the vehicles is to be supplied according to their requirement.
He used to supply.
Yes. Mechanical, like as mechanical, from store.
From store,
Yes,
he used to.
To the garage.
So anybody would come to him and ask him to deliver the parts.
Yes.
It was an internal arrangement.
Internal arrangement. Within the office.
Who kept that record as to which part he was giving?
One of the storekeeper.
Huh?
One of the storekeeper.
One of the storekeeper.
Storekeeper. He is also an employee of that office. He was also an employee of that office, being a storekeeper.
He did not sign any requisition on.
Only for directions to supply these parts to the garage. Then I have done.
So you were just a labor.
Yes, just a labor. Worker.
So requisition.
Permanent.
The requisitions were not signed by you.
Requisition signed. Yes. That.
Where are those signatures on the requisitions that he used to sign on a day-to-day basis?
That requisition signatures is not kept with these with my clients office during the period. Even
so that it must be there. Otherwise, how can you claim that you went there to work for 760 days?
Your Lordship, kindly, only 1 minute, your Lordship, gone through this, the applications reply. Having after my lord stockage notice was issued, then I have already given a reply. That is page. Entirely, my lord, I have.
Now, what are you claiming? That you went and worked
Claiming
for?
I am to my lord, release the pension as well as the other retirement benefit because I have already retired in 2012, 31st December. Prior to that, my lord, I have been my lord, demotions of my post. And accordingly, they
So
have
you
been
mean
some
to say
lump
every
sum amount.
day for 716 days,
716 days.
he used to go to that depot, he used to work, but he was not allowed to
Join. Or not to allow to work.
Huh?
Not to allow to work.
Not to allow to work. Now,
No,
just now
no,
he
no.
said he used to work.
Not to allow to join. Or sign in the register. And that's why my lord, he was unauthorized absented. Ultimately.
You did not bring this to the notice of these superiors.
I have already given reply. That's
No,
why my lord, I am saying that.
that you had not been allowed to sign
Right.
the register, your attendance register. Didn't you bring it to the notice of your superiors?
My lord, I have already given the reply. Even our union is also my lord, given a reply. That as to why this particularly person has been my lord, imposed of such of such type of allegation.
What allegation?
Yes. That is my lord, as it appears, my lord, it has been annexed in this petition. Having after joining my lord.
Sir, what is the issue? You did not allow them to allow him to join.
It is page my lord 61, annexer P5. No, 67.
He was working for you for 760 days, and how come you prevented him from joining?
No, my lord, that
Availed
is
of his services, yet you didn't allow him to join.
my lord, the petitioner's version. That is the petitioner's version. My lord, very hard to my lord the chewing that.
Very hard to digest.
Very hard to chewing. Yeah, naturally, very hard to accept that for more than 700 days, a laborer or a postman, whatever be his status, he went to his my lord the job site, presented himself, served there, workplace, went there, served there, but without any my lord salaries, wages, days, months together, then filed writ petition, and then when in 2006 the writ court said that you have to join there, then he filed a joining report. If your lordship kindly, my lord, come to one page, page number 66.
66
of the writ petition.
Yes.
Page number 66. This is the first time the joining report to the depot in charge, signed by the petitioner, date 23rd February 2006. Contains, I the undersigned do hereby report to join my duties to my work as directed by the Honorable High Court by its order dated 22nd of February 2006, along with the fit certificate as directed by the Honorable High Court. Kindly accept my joining report. Allow me to work on and from 23rd February 2006. This is the first time after that 2004. Now, Lordship, kindly, my Lord, come to, yes, I have to draw your Lordship's kind attention to that particular averment where this annexure P4 mentioned. My Lord, that is, my Lord, paragraph. Annexure P4 mentioned at, my Lord, paragraph number. এক্ষুনি দেখালাম তোমাকে এক্ষুনি তোমাকে দেখালাম যে প্যারাগ্রাফে P4 এটা P6 এর আগে হবে
is 19.
পেজ 18 হবে
Italy continue 17 number there.
Annexure P4
না না এটা না
This is certain right?
P4 P4
Page 12, paragraph 15.
এক মিনিট দাঁড়াও চুপ করুন Yes. Get progress. Well, may I read out?
So you read from 14,
Yes.
paragraph 14.
According to the petitioner's version, petitioner duly signed the attendance register on 8th March 2004 and joined his duty. Then the petitioner took medical leave with effect from 9th March 2004 to 18th May 2004, which was granted by the respondent. Thereafter, by letter dated 19th May 2004, petitioner prayed for accepting his joining. He duly joined to Ultodanga Depot on 19th May 2004 by signing the attendance register on that particular day. Then, that being agreed by, all on a sudden jump, then that being agreed by and dissatisfied with the action of the respondents in not paying petitioners due salaries and withholding the same, not allowing the petitioner to work in the Ultodanga Depot, petitioner filed writ petition number such and such of 2006 after about 2 years. Then, as per direction of the Honorable Court dated February 22nd, 2006, petitioner filed his joining report by his letter dated February 23, 2006, along with fit certificate as directed by the Honorable High Court and joining report annexed to P4. It is crystal clear from this that he reported on 19th May 2004. And then after that, he did not, made himself, present in his workplace. After that, he filed a writ petition after about 2 years, and then the order passed.
That was on what ground, sir?
Not salary.
Because he's claiming
My lord.
his financial benefits as because you must have not paid.
No, because he did not work. He was absent. May I tell you, Lord, it should be our duty, to place a very short list of dates. If you Lordship kindly have a look, I think everything would be clear from this. A short list of dates. My lord.
Now this,
Lordship kindly,
sir,
this is
this
very.
portion, he
Yes.
says that he used to go and you did not allow him to sign the.
And that is why the writ petition filed and the writ court said that there should be an inquiry by the authority concerned that to ascertain whether he joined or he presented himself, and he was, my lord, he was not allowed to. Then the inquiry and the proceeding concluded. My lord, appeared before the inquiring officer. The inquiring officer was none else by the divisional manager. And then the inquiry report, then, my lord, the report submitted to the disciplinary authority. Then the final, my lord, the entire thing came to an end by way of that order passed, which is challenged herein. My lordship, kindly come to, my lord, this list of dates, very short list of dates. If your lordship, 31st of January 2004.
Sir, I have seen that.
Yes.
You come to page 2, 4/10/2004. They filed the.
No, this is important. Lordship, kindly come to the third, my lord, the paragraph on 8th March 2004. Writ petitioner was shown released from because of his transfer, he did not accept his transfer.
Yes, sir.
Petitioner was shown released from Ultodanga Depot, was directed to join at his new place of posting. The petitioner kept himself absent and thus avoided to accept the release order. Exactly this is, my lord, in our, my lord, opposition. We have stated that on oath. Then the petitioner reached Ultodanga Depot on 19th May, sought to join his service. That 19th May, yes, we also corroborate this. 19th May, all on a sudden, he went there. He wanted to join his service, 19th May. Then let's see what happened.
19th May he signed, then again continuous absent after that from 19th May 2004 till the time herein after stated. Petitioner continued his absence in workplace. Then 4th October 2004, by an interim order of even date passed in such and such, transfer order was directed to remain stayed if the petitioner has not already been released. That was a rider therein, that if he has not yet been released, then my lord, what happened? He did not join, then what happened? 1st February 2006, the contempt application CPM 525 of 2005 arising out of that earlier writ petition filed by the present petitioner was dismissed with a finding no reason to issue contempt rule. That writ petition was filed in 2006, that I went there, I used to go there, but my salaries, they have not, my lord, disbursed my salaries. So this order be passed so that, and contempt. The contempt court said, no, there is nothing to proceed in this contempt petition because you failed to satisfy the court. So contempt proceeding was dropped. Then in 2007, so-called notice of even date was served upon the petitioner seeking reply as to why stern disciplinary action should not be taken against him for keeping himself absent for the period from 9th May 2004 to 22nd February 2007, that is 716 days. Then on 22nd November 2004, he in writing replied, and then 16th May, subsequent writ petition, very important, lordship, being WP number such and such of 2006 filed by the present petitioner, that was disposed of by a coordinate bench directing inter alia the respondent NBSTC to make an inquiry to ascertain as to whether during the period from March 9, 2004 to February 22nd, 2006, the petitioner had absented himself or was prevented from attending his office, and to decide whether from 23rd of February 2006, the petitioner had been paid less than his entitlement, to give a decision within a week. Accordingly, the respondent corporation by memo even date appointed inquiry officer to inquire the case, and then the inquiry officer by memo of even date requested the petitioner to appear before him on 20th May 2012. And then on 20th May 2012, petitioner duly appeared before the inquiring officer and deposed evasively before the inquiring authority. Then 30th May, because my lord, that order contained that within a very short period, the inquiry proceeding should be concluded. Then 30th May 2012, the inquiring officer prepared and submitted his report, thereby coming to a finding that the charges leveled against the petitioner as unauthorized absence had been proved. And then finally on 31st May 2012, my lord, the disciplinary authority, being the managing director of the respondent corporation, passed the final order in the said disciplinary proceedings, thereby reverting the petitioner to master role status. So this is the case. Now, he said that he was prevented. Now, in his writ petition, an order was passed directing the NBSTC, the employer, to inquire and come to a finding by way of, my lord, fixing the inquiring officer. Inquiring officer asked him to come and depose, going through all papers. Now, the factual aspects, that is the question, is that whether the writ court can again go to that whether at that point of time, when for that during that 2 years, his version is that he went there, he presented himself, he used to work, but we are saying, we are denying that question ended so far that factual aspect. He accepted that order passed by the writ court, accepted that, presented himself before the inquiring authority. So that chapter is now over, my humble submission, that factual aspect, that finding, now it reached to finality after the, my lord, the order and or finding of the inquiring authority.
Okay, sir. Ashwin.
My lord. My lord, so for this, my lord, regarding this, as per
my lord, there are some judgments.
Sir, you can file written notes.
Very good. Very good.
You will file anything?
Because
sir?
my lord, only thing, may I tell one thing? My lord knows this very well. that it is not his case that there was no evidence. Now, my lord knows very well that in a disciplinary proceeding, only in case of if there is no evidence or there is any perversity or contrary to the statutory provision or the rules regarding their service rules, then only, my lord, it is question of interference. It is none of this, my lord. It is his case. That no evidence, no, there are evidence. So, my lord, I shall file my argument.
So far, this submission, I shall give a reply on the next day.
Okay. Heard the submission of learned advocates representing.
So, my lord, hearing concluded or my lord?
Hearing.
So you file the written notes, sir.
Written no, I shall file written notes.
So, heard the
both-
submission
both
of
will be the
learned
written notes
advocates
over.
representing the respective parties, written notes to be filed by the learned advocates representing the petitioner as well as the respondent. CSTC, sir.
CST.
No.
NBSTC.
Lord.
NBSTC.
NBST.
On the next date of hearing. 9th of September.
My lord.
Next date we fix on 9th September at 2 p.m.
Only thing is that, my lord, after my new assignment, now I have stopped to accept there any new brief from this undertaking.
What is your new assignment?
My lord.
Additional Advocate General of the state of West Bengal.
When did this happen?
My lord, 31st of July, the notification issue. 31st of
He
July.
was always our pride. Now he's the state's pride.
Though, but these are old matters. I
Sir,
have
you
to
can
finish.
appear in the old matters.
Yes, I have to finish it. Get.
My lord, Mr. Chatterjee is here.
Not
Yes, Mr. Chatterjee, in every matter you people need to be called.
And I always, try I am always there. In some matters I miss, my clerk has missed this matter, So we are bound by the, our stand is clear from page 32, my lord will find it. Is the reasoned order.
No, sir, you will be filing affidavit in opposition.
It will be fit to file, I believe, my lord.
No, on the earlier occasion you said if
You-
required you will
Right,
be
right.
filing.
You
didn't go through the brief.
I went through the brief, my lord. But my lord, your lordship says my stand is clear from page 32. That's the reasoned order. I have provided
32 of the
of the writ petition. That is the reasoned order, my lord, whereby I say, my lord, that he is not entitled to, because the nature of the job is also different, and page 32 of the reasoned order, your lordship will find.
Then, my lord, I have to start from the beginning.
But nevertheless, my lord,
So this page 32 and page 33 will suffice your contention?
my lord, possibly I should use an affidavit. My lord will kindly give me leave to, my lord. Your lordship has already given leave. My lord, only kindly extend the time, allow me to come back, your lordship.
My lord, kindly give me a short date, my lord. My lord, he said 2012 writ petition 2012. My lord, all are old aged senior citizens. My lord, kindly, my lord, consider, my lord.
How long will you take, sir?
3 weeks, my lord, kindly give me.
3 weeks.
Short affidavit,
Finance
my lord.
department affidavit, my lord, they will contact the parent department now. As your lordship pleases, my lord.
On the prayer of learned advocate representing the state.
My lord.
CSTC?
My lord, my report has already been filed, my lord.
Report no opposition.
The opposition has been filed, reaffirmed, and I have filed it, my lord.
You have filed it?
Yes, my lord, it is there. My opposition was filed earlier only, my lord. But since there was a direction from this court to reaffirm and file it again, it has been filed.
Next date we fixed on 12th of September.
Well, may I have the copy of the opposition filed by CS? That will help me, my lord, discuss the matter.
I'll just instruct my junior to hand over a copy to the lord.
Filing the affidavit in opposition as last chance. If this rider
Sir,
doesn't
no, I don't fail, my lord. When your lordship specifically grants me opportunity, my lord.
Sir, you give him a copy of your affidavit
I
in
just now hand over a copy to my learned friend.
We are grateful, my lord.
Much obliged. Much obliged.
আর কিছু বাকি আছে? এটা কিসের জন্য আছে? এফএমএ এখন ডাকতে হবে না, আর একটা যেটা আছে রেকর্ডের ইস্যুটা, রেকর্ডটা কোথায়? Sir, I'll take up your matter once I finish it off, and I'll call your matters then. When the FMA matters are called, sir, then I'll take up your matter. Now your can application এসছে?
Only 76 days of
70 না
and
আসুন।
my understanding are opposite. There is only 76 days delay in filing the another fact is that, madam,
4, 5, 6. Not plan to dispose of. Who will file the paper book?
I'll file the paper in form of paper and what about maybe call for you special messenger first.
Which is the district?
General. I have already filed what
Railway Claims Tribunal, Kolkata. Acha. The Learned Registered Judicial Service to call for the TCR from the concerned bench of Railway Claims Tribunal, Kolkata, prior to the next date of hearing. Next date is fixed on 15th of September.
This is my lord, the tribunal has placed the change. It is now 14th.
Huh?
Tribunal address has been changed. It is now in 14th Stand Road. At that time, it was not in the 14th Stand Road. It was in আগে কোথায় ছিল?
So you write the new address and give it to them. Next.
14th Stand Road, Kolkata.
Beginning part of
14th Stand Road.
হঠাৎ কোথায় আছে? আচ্ছা। None appeared to represent either of the parties. Let the matter be fixed for CAV. Next. আচ্ছা একটা এটা আছে না, এইগুলো তো না, এটা তো এইটা ছাড়া একটা আছে না, এই 165টা।
I'm for the petition, my lord. On last occasion, your lordship pleased to pass a direction upon me to file affidavit of service. May be permitted to file my affidavit of service, my lord.
My lord, I am for the state respondents in this matter, man. State respondents.
Yes, you have.
But my lord, the presence of the municipality, I think, is required. Because
My lord, in this writ petition, my lord, I am praying for a direction upon the Kolkata Municipal Corporation to implement an order which was passed by them, my lord. That is page number.
Now, who is a
Page number 38, my lord.
municipal corporation is respondent number?
My lord, municipal corporation is respondent number, my lord. Respondent number 2 to
Did you serve
5.
fees upon them?
Yes, my lord. Respondent number 2 to 5, my lord. Municipal corporation.
Who generally appears for them? Who generally appears for them?
My lord, the Kolkata Municipal Corporation, my lord, Mr. Alok Basu is there, my lord.
Who appeared?
Upon whom have you
লাস্ট অকেশনে
served?
তো কেউ অ্যাপিয়ার করেনি, লাস্ট অকেশনে কেউ অ্যাপিয়ার করেনি, এই তো।
তার আগে?
আগে তার আগের অর্ডার গুলো
হ্যাঁ, লিখুন।
My lord, subject to your lordship's approval, my lord, since last two occasions they have not appeared, lordship may kindly direct my learned friend to serve a copy upon the municipal commissioner, that is respond number 3.
The affidavit of service filed by the
Makes-
learned advocate
that's the
representing the petitioner be kept on record.
আপনার petition এ তো
Sir,
my lord,
you will be appearing for the state respondent.
my lord,
Number? Learned ওনার নামটা দিয়ে have you
my lord,
been
respondent number 1, respondent number 6, 7 and 8.
Have you been engaged?
Yes, my lord.
Such and such ওর নামটা দিয়ে has submitted to have been engaged to represent state respondents. Number 1,
My lord, number 1,
comma,
number 6, 7 and 8.
6, 7 and 8. Full stop. The learned registrar administration LOM is to serve notice upon the municipal commissioner.
Respond number 2.
Respond number 2, my lord.
Respondent number 2 and
Commissioner is 2.
2 and 4.
My lord, the commissioner is 2 only. The municipality, the other authorities
Authority
are
is
there, my lord.
4 and 5.
They are from respondent number 2, 3, 4 and 5.
2, 3,
2
4.
to 5, their municipality.
3, 4
I have
and
already
5,
served all of them, my lord.
intimating the next date of hearing for the appropriate representation before the court and file an affidavit of service to that effect. Next date be fixed on 8th of September.
My lord, next day,
8th of September.
lordship. I have already served all of them, my lord. KMC. I'm grateful.
দেখুন 3টের সময় যেটা আছে fix করুন।
Hey. Okay. Make this a lordship. Well, last time, my lord, I was subject to your lordship with regard to the decision cited by Mr. Gupta, Mr. Lokhi Gupta. My lord, that is reported in, my lord, with regard to registration, non-registration of the document entitles the respondent to contend that that document should not be looked into. And he has cited 2022 15 Supreme Court cases, which I had already dealt with. I shall just remind your lordship, this is the judgment of the Supreme Court, which, my lord, considering the earlier judgments also, had come to this finding. My lord, I shall just draw your lordship's attention to the ultimate decision of the Supreme Court. A number of decisions has been considered, and this says what it says. My lord, kindly come to the, after the judgments have been, all these judgments have been considered.
Which one, sir? কোথায় judgment? এটা তো নয়।
This is 2022 15 Supreme Court cases. এটা বোধহয় উপরই থাকবে নাকি? 2022 15 Supreme Court cases. This is on Registration Act. And the argument was that in so far as the first agreement is concerned, That is, my lord, the dated my lord, this dated I shall give your lordship the date. 22nd February 2002. If your lordship takes the compilation, the one item number 12 at page 28. Unregistered deed of lease was executed, in pursuance of which, my lord, possession was given, payment was made, registered power of attorney was executed. My lord, that particular document, 22nd February, 22nd February, তো ইউজ করছি শোনা যাচ্ছে না? আমি তোমাকে তুমি আছো আমি সেটা জজকে বলে এসেছি যে আমার এখানে আটকে গেলে কি করে যাবো আর আমি কি করে বলি হ্যাঁ তুমি বলে দিই যে আমি কখনো আটকে গেছি
Yes, sir. Let us continue.
Yes, ma'am. Kindly, my lord, come to pay this judgment. The argument was this 22nd February, my lord, your lordship has got the compilation.
Yes.
22nd February 2002 document, my lord, unregistered deed of lease. Since it is unregistered, it could not have, my lord, affected the immovable property, which is the subject matter of it. And for that, my lord, the submission was made and this judgment was cited. This 2022-12 Supreme Court cases. Kindly come to paragraph 36. And it says that if we apply the test as to whether so and so, in this case, by itself affects, that is, by itself creates, declares, limits, or extinguishes rights in the immovable properties in question, or whether it merely refers to what the appellant alleged were past transactions which have been entered into by the parties, then going by the words used in the document, they indicate that the words are intended to refer to arrangements allegedly which the parties made in the past. The document does not purport to by itself create, declare, assign, extinguish, or limit rights in the properties. Thus, so and so may not attract Section 49A. As far as Section 49C of the Registration Act is concerned, it provides for the other consequences of a compulsorily registrable document not being so registered. That is, under Section 49A, a compulsorily registrable document which is not registered cannot produce any effect on the rights in immovable property by way of creation, declaration, assignment, limiting, or extinguishment. Since 49C is in effect reinforces and safeguards against dilution of the mandate under Section 49A. Thus, it prevents an unregistered document being used as evidence of transactions which affects immovable property. So, my lord, this is what was relied upon, and the submission was made that this document dated 22nd February 2002 at pages 28 to 46, my lord, that is not going to have any effect on the property which was sought to be made over in pursuance of this agreement. Well, my answer is twofold. First, my answer is, your lordship will please to see that I am not relying upon this document only. This particular agreement fructified into a registered document, registered deed. This is, my lord, that your lordship will please to find at page 86. Kindly come, my lord, to item 29, 23rd April 2010. Kindly come to this compendium of documents. Page 86. So, in fact, what happened was this NBSTC, North Bengal State Transport Corporation, this had on this particular date, 23rd April 2010, got this agreement of lease registered. So a registered document was executed. So the moment, my lord, this document became registered, this embargo, impediment created by Section 49C goes.
So this is a complete answer to my learned friend's submission that by reason of the agreement which was executed, my lord, earlier in 2002, no right could be created. I am answering that quite apart from anything else, this particular document has been registered already. So once it is registered, my right fructifies. My right, which was inchoate at that particular point of time, fructifies into, my lord, a right in the immovable property. So that is my first submission. Second submission is that, my lord, well, my second submission is this, sir. Kindly come to section 49, which has been quoted in this judgment. I am not troubling your lordship with, my lord, the Registration Act. This has been quoted in this judgment. Kindly come to page 484 of this.
Uni non. Oi.
Kindly come to paragraph 13 of this judgment. Well, paragraph 13 of this judgment, my lord, section 49 has been quoted. Your lordship sees.
Yes.
So, my lord, first part of the operative part of this section says that without registration, a document cannot affect the immovable property. To which I have answered that this document had been registered in 2010. Therefore, this particular objection goes. My second submission is this. Kindly, my lord, take section 49 once more, which is quoted here. I am not troubling your lordship with the Registration Act.
Yes, sir.
Paragraph 13.
Yes, I'm there only.
49. No document required by section 171 or by any provision of the Transfer of Property Act 1882 to be registered shall affect any immovable property comprised therein. This I have answered. Confer any power to adopt. It is not applicable. C. Be received as evidence of any transaction affecting such property or conferring such power, unless it has been registered. This is answered by my submission that the document had been registered in 2010. Then proviso is very important also for my purpose, provided that an unregistered document affecting immovable property and required by this Act or Transfer of Property Act to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act, or as evidence of any collateral transaction not required to be effected by registered instrument. Now, in pursuance of that agreement of 2002, various acts have done. First of all, money has been paid. Secondly, my lord, building plan has been sanctioned. Then thirdly, my lord, ground rent has been paid. All these are admitted facts on the documents. And huge amounts have been paid, and they have been accepted. 13 crores of rupees had been paid before, my lord, this registered document was. Now, my lord, these are collateral transactions, collateral to the transaction with regard to immovable property. Now, transaction with regard to immovable property has been, my lord, effected by the 2010 registered document. And, my lord, prior to that, all these collateral, my lord, activities have taken place in respect of this property, which have been, my lord, accepted by the parties. So my respectful submission is this, that even though your lordship cannot, by reason of section 49, come to the conclusion that the immovable property has been affected by this document, by 2002 document, but insofar as other transactions, collateral transactions are concerned, as contained in the agreement with regard to payment of money, my lord, submission of plan, building plan, sanction of building plan, payment of money, whatever it is are there, they will not be affected by section 49, because these are collateral transactions. And I have given your lordship the different, my lord, documents which clearly go to show this collateral transaction. But be that as it may, once that document has been, my lord, registered.
But sir, they have raised an issue
Lordship.
as far as the registration is concerned.
Yes.
So if we come to the executing part,
Yes.
at the end, no, in page 109.
109. Yes, sir.
Now they had stated that this managing director
Yes.
to have signed on behalf of MA Construct.
Correct.
Right, sir? As well as on the basis of that power of attorney.
Registered power of attorney.
Registered power of attorney. And thereafter, in the similar capacity as the MA Construction, I mean,
absolutely,
and Trading Company Limited,
well, I'm very
which they are saying is contrary to law. In similar capacities, you have done it, and you have done it without our consensus. That was the submission.
My lord, may I draw your lordship's attention in this connection to the letter dated? Your lordship, kindly come to page 85. Kindly come to page 85. Letter dated 19 January 2010. Well, it seems, my lord, my friend, my lord, really forgot about this letter, which was written by his client. Kindly read this letter. May I place it? Please. This is a complete answer. Kindly see, my lord, who has written this? NBSTC. North Bengal is writing. Those party who is
later on they have disowned you, sir. So what is your?
My submission is they have themselves asked me to sign. I have signed it at their instance. Power of attorney they have given, which entitles me to sign. Secondly, my lord, they have instigated me to sign. Kindly see, can a person turn around and say that you didn't have any authority after this letter? A person cannot approbate and reprobate. This is exactly what it is. Kindly, my lord, take this letter at 19 January 2010 at page 95. This letter is to be read, my lord, along with the power of attorney. Kindly see, my lord, what it means. MA Construction is being addressed. Dear sir, in reference to your letter dated 11 January 2010 on the above stated subject, this is to inform you that permissive possession of the land and building of Ultodanga bus terminus was given to you long back in 2002 with a registered power of attorney. Kindly note this, so as to enable you to take all necessary steps on behalf of the corporation, being the constituted attorney, and to do all acts and things as you think fit and expedient for materialization of the project. Until date, the said power of attorney is valid and in full force, but you did not put the same into effect. Kindly see the next paragraph. However, since you have already paid rupees 13.06 crores to NBSTC, that is more than 50% of the lease value, and further agreed to make payment of at least 3 to 4 crores towards statutory liabilities of the corporation, and also agreed to make payment of the balance lease value as early as possible, and considering the situation that unless the said notarized agreement to lease is converted into a registered one, you are not in a position to progress with the work. We said that I have got an unregistered agreement. You make it registered, then only I can. And to that, they're answering. Unless the notarized agreement to lease is converted into a registered one, you are not in a position to progress the work. As such, the corporation has decided to accept your proposal for registration of the said notarized document. Accordingly, you are directed to exercise powers already delegated to you by the registered power of attorney, and being the constituted attorney of NBSTC, you are authorized. That means, my lord, MA Construction is authorized to sign the document and present the same before the competent authority for registration of the agreement to lease dated 22nd February 2002. That is the unregistered agreement. without any further delay. The corporation will not bear any cost or expenditure on this account. A copy of the registered document may kindly be produced. So well, after this, how can they say? Therefore, what happened was this. In 2002 unregistered agreement, this unregistered agreement was not being registered. Why? The registration has to be, my lord, document has to be signed by NBSTC. NBSTC, I approached NBSTC that look, you will have to sign this registered document. The document to get it registered. Why don't you sign it? NBSTC turned around and said, I have given you power of attorney, registered power of attorney. Therefore, you sign it on my behalf. I have signed it on their behalf. Can they now today turn around and say that, look, you have signed it, I have not signed it. This is not a proper signature. At their instance, I am doing it. This document is dated 19 January 2010, and your lordship has been pleased to see the registered agreement is dated 23rd April 2010. Within 2 months, my lord, it was done. At their instance. So, my lord, this.
But they said, sir, the power of attorney had a specific time period for its effectivity, and with thereafter it lost its legal validity.
That is a wrong statement. That is a wrong statement. Kindly see the power of attorney. Let us look at the power, page 51. If your lordship looks at the agreement, the power of attorney, my lord, agreement, your lordship is pleased to see the agreement is dated 2002.
Power of attorney is at which page, sir?
At page 51. Well, unregistered agreement of 22nd February 2002. Registered power of attorney 21st August 2002. And my lord, registered document in 2010. So the story is complete. Power of attorney, page 51. And we see, my lord, there is no such embargo in the time fixed period or anything like that in this. Page 60.
Yes.
Your lordship will please to come to 2 or 3 clauses. Well, kindly see page 54. The operative portion, the amendment portion. Now know ye all men by these presents that the appointed do hereby make, nominate, constitute, retain, and appoint, and have made, nominated, constituted, retained, and appointed the said MA Construction and Trading Company Private Limited of so and so address as the true and lawful attorney to act in the name of, on behalf of, and on account of the appointed. So I have acted on behalf of the appointed by signing the document. The document is, I have been specifically, my lord, asked as a true and lawful attorney to act in the name of, on behalf of, and on account of the appointed, and do all on any of the acts, deeds, matters, things, namely. Now, my lord, kindly see, my lord, that 1 or 2 clauses of this. What I have been empowered to do and what I have done. Lordship will please to see. Kindly come to clause. First is B. Kindly come to. I am not troubling your lordship with A. This is with regard to possession of the immovable property. Then to appear and represent the appointer before Kolkata Improvement Trust, Kolkata Municipal Corporation, Police Authority, and other government departments and or authorities in connection with matters relating to the development of demised premises and or construction of the proposed new multi-story building. In pursuance of this B, I have, my lord, prepared the plan, the building plan, and had given to the municipal authorities for sanction. Then, my lord, to get necessary plans, maps, diagrams, sketches, and elevation prepared for the development of the demised premises and or construction of the proposed new building for obtaining necessary approval. Then, my lord, kindly see. Kindly come to.
So they were harping on the registration part, that this power of attorney did not confer you the rights to get into any registration of the deed
I am.
Though the page number 85
Yes.
that you mentioned, it specifically stated that by dint of that power of attorney, you could have got that agreement to lease registered.
Without
But according to them, so this power of attorney
does not
did
give me the
not
right.
specify that you could have registered the agreement to lease.
Your Lordship kindly comes to page 57, J. Page 57J. This is a comprehensive power of attorney, gives you all the power with regard to this immovable property. Kindly see J. To do all acts, deeds, and matters, and things as may from time to time be necessary or required for observing, performing the various terms and conditions and covenants and stipulations contained in the said original lease deed dated 22nd November 1995 and on the part of the appointed be observed and performed. Everything I am entitled to. Kindly may not also turn round. Your Lordship will please to come to clause N at page 58. To apply for and obtain loans and advances from banks, financial institutions, and other persons or parties as may from time to time be required for carrying out the development of the demised premises and or construction of the proposed multi-story building, and further to secure due payment of such loans and their advances by creating charge or mortgage over the appointer's leasehold rights in respect of the demised premises under the said lease deed dated so and so, and for the said purpose to sign, execute, register, and deliver all deeds, documents, and papers, including memorandum of deposit of title deeds, mortgage deeds, and other papers and documents. Complete power had been given. I have been given the right to even to mortgage the property on their behalf. And my lord, to execute all deeds and documents. How can they, my lord, get out of this? My lord, these are technical points which are sought to be raised, which are not supported by the documents. Then, my lord, kindly see page 60. This is, my lord, the residuary clause, which completely covers everything. W. And generally to do all that is or may be necessary for smooth development of the demised premises and or construction of the proposed building thereat, and further for carrying out the obligations under the agreement of lease dated 22nd February 2002, and as the said attorney from time to time think proper. Complete power given. In fact, my lord, what happens is this. In practical life, when a registered power of attorney is given to a party, that particular party is empowered to do everything that is required with regard to this property, whichever property, to get the plan sanction for it, to make construction of the building, to let it out to parties, outside parties, to mortgage the property for the purpose of raising loan, to execute and register deeds. My lord, in pursuance of this and in pursuance of that letter, which was specifically written, please get this particular lease registered. I have given you the power of attorney. Why are you not getting it registered? That is the tone of that letter. Is that you are making an excuse for not getting it registered. I have given you the power. Why are you not getting it registered? That letter was written, and thereafter I got it registered. After I get it registered, now they take the point that you didn't have the power, didn't have the authority. What kind of a stand the government is taking? I'm absolutely appalled. I'm surprised. Government, my lord, after all, my lord, the government of the people, they are taking the stand after, my lord, leading me up the garden path. They are saying that, how are you doing this? I say that, my lord, factually, your lordship doesn't have to go into any law.
But sir, they challenge your status also.
My lord?
First of all, they said that the lowest bidder could not be granted the contract. Thereafter, you came into the picture, and that was not through a proper legal process.
I
That
could-
is their contention.
My lord, I understand, I appreciate. If, my lord, this particular contention had been put in the form of an action, I would have been out of court. Now, if, my lord, let us say that this is the argument which is a substantial argument.
And thereafter they said they made a mistake and they could not be allowed to continue with the mistake.
The mistake was, they committed a mistake by taking 13 crores of rupees from me, by taking, my lord, the ground rent for 99 years, by, my lord, allowing me to get the plan prepared and placed before the Calcutta Municipal Corporation. My lord, some amount of, I expect some amount of honesty, some amount of bona fide on the part of the government authorities. Who are they? State of West Bengal. Who are they? NBSTC. Who are they? Kolkata Improvement Trust. Who are they? Corporation of Calcutta. 4, my lord, bodies which, my lord, regulate your lordship's life and my life. And today, after, my lord, leading us the garden path, they say that you didn't have. My lord, suppose, let us assume for the sake of argument that this particular agreement should not have been given to me. It was by mistake given. Then what should have been done? They should have cancelled the agreement. They should have said that no, don't proceed any further. They should have said, don't pay me 13 crores of rupees. They should have said that don't place the plans for sanction to the municipal authorities. But there has to be some kind of bona fide on the part of the government. Government cannot, my lord, act like a my lord, what should I say? But I was a businessman. They cannot act like that. My lord, the citizens of the country expect, my lord, at least basic minimum honesty on the part of the government. Government cannot say so. Government cannot say so because, my lord, for 10 years, 8 years, my lord, I have done it. I have done whatever I have to do. And then, my lord, you take money from me and then you turn around. What kind of a government is this? And if this is not mala fide, my lord, what is it? I am challenging, my lord, I am questioning, my lord, the attitude of the government, not only in the affidavit, but also of the submissions made. This, my lord, the roadblocks which have been put in front of me throughout by the KIT, by the, my lord, the government, by, my lord, the Calcutta Municipal Corporation. What does it say? It says, I have taken the money. Crores of rupees they have taken. How much money have they taken now? Check. They have taken for sanction as sanction fee. And then, my lord, they say, sorry, I cannot sanction the plan on your behalf because KIT is saying that don't do it. So since KIT is saying, where, my lord, in the Calcutta Municipal Corporation Act, there is any provision that KIT can put a spanner in the works? Well, there has to be some kind of bona fide on the part of the government. There has got to be some kind of a bona fide on the part. Well, they say that this particular party was not acceptable to me. I never agreed. What does KIT say? I never agreed to, my lord, this particular writ petitioner being given the contract. Well, does it lie with them? I shall show your lordship the documents. After these documents, my lord, does it lie with them? Kindly, my lord, come to page 69. See this document. Kindly see this document. I only 5 documents. I refresh your lordship's memory in that. Well, unless there is absolute amnesia on the part of the government and its government bodies, I respectfully submit to your lordship, this submission could not have been made. Kindly, my lord, take page 69. This is dated 8 September 2004. The 4 documents I am placing before lordship. Who has written it? Chief Inspector, NBSTC and Liaison Officer, Transport Department, Government of West Bengal. Written to the Officer on Special Duty, Improvement Trust, Kolkata Improvement Trust. Your lordship, when you see, I am directed to draw your kind attention to the fact that NBSTC is the owner leaseholder of a plot of land of KIT, earlier known as CIT, at the crossing of EM bypass and Sotyenbo Sharoni, formerly CIT road. NBSTC authority desired to exploit the said land on commercial basis, for which it was leased by the government that NBSTC will pay rupees 2 crores to CIT for issue of written consent in terms of clause so and so of the lease agreement dated 22nd November 1995. In fact, NBSTC is not in a position to pay the said amount to CIT due to its financial hardship. It is also known that a building plan on this score is under the process by KMC, where such written consent from KIT is required. It is also stated here that unless the said building plan is sanctioned, NBSTC could not raise funds to meet its liabilities. On this context, I am directed to undertake before you that NBSTC will pay 2 crores to KIT within 60 days from the date of sanction of the building plan, and would request you to kindly give necessary permission and or NOC to NBSTC or such commercial exploitation of the said leasehold. And this is signed by the Chief Inspector, NBSTC Liaison Officer, Transport Department, Government of West Bengal. See, my lord, then page 70. Who is writing this letter? It is Officer on Special Duty of KIT. The person, my lord, KIT, who is saying that I am not entitled to recognize my client. They are writing this letter, my lord, kindly see what they are writing. Joint Secretary, Government of West Bengal. In reference to a letter dated 8/10/2004, with a commitment to pay 2 crores to KIT within 60 days from the date of sanction of the building plan for commercial utilization of the leasehold land at the junction of Sotyenbo Road, EM bypass, so and so, on the following terms and conditions: that no objection certificate would be issued to NBSTC for commercial utilization of the land leased out by KIT to NBSTC to facilitate sanction of their building plan by KMC on the block of land on the junction of Sotyenbo, Sharoni and Eastern Metropolitan Bypass, on condition of deposit of rupees 2 crores by NBSTC to KIT within 60 days from the date of issue of no objection certificate approval of the building plan of KIT. That NBSTC should submit 6 sets of building plans, both architectural and structural, on the proposed commercial building with the requisite fees of 5,000 to KIT approval for holding plan. This is 70. Kindly come to 71. What Kolkata Improvement Trust writes, KIT, who says that I don't recognize. See, my lord, what?
So in page 70,
yes,
this officer on special duty is of the KIT.
Officer on special duty of KIT. This is a KIT's letter. To my lord, the Joint Secretary, in reply to the letter which I have placed before lordship. This is, my lord, their letter. Then, my lord, another letter by KIT. Kolkata Improvement Trust is writing to the Chief Inspector, NBSTC Liaison Officer, Transport Department, with reference to a memo dated so and so, enclosing 6 sets of building plans for the proposed building at the block of land leased out to NBSTC at the junction of Sotyenbo Sharoni and EM bypass at scheme so and so approved by KIT. I am enclosing here with 3 sets of approved building plans comprising of 3 numbers each of architectural and structural drawing. Well, my submission is this: when the plan was given, the plan must have been having the name of my lord, this MB Construction, the writ petitioner. They, my lord, approved it and sent it back. That is not the end of the matter. Kindly come to the next part. This is a letter given by NBSTC, specifically mentioning my name. And they say that I don't know. Estate Manager, Kolkata Improvement Trust. This letter had been written, not disputed, not denied, 14th November 2007. payment of ground rent for the leasehold land at the junction of EM bypass and Shotenbo Shoroli. The subject premises was leased out to NBSTC by KIT, then CIT, for a term of 99 years commencing from so and so, by executing registered lease date in 1995, wherein the ground rent was determined fixed at rupees so and so per annum, payable by the LAC NBSTC to lessor KIT. Since execution of the said lease, ground rent was not paid by NBSTC. NBSTC is admitting that not paid. Now, I am forwarding here with a demand draft of rupees 1,31,890 drawn in favor of Kolkata Improvement Trust on account of the said ground rent for the period from 12/10/2019 to 12/10/2007, 18 years. The draft has been prepared through MA Construction and Trading Company. My name has been specifically given, who had been engaged by NBSTC to develop the said land. Kindly accept the draft on account of NBSTC. My lord, this is the draft at page 73 with the name of MA Construction written. Kindly come to page 73. 1,31,000 MA Construction written. Then kindly come to page 74. These are documents, my lord.
Page
Larger than life, staring at them at their face.
According to you, page 74 had mentioned the entire period of 99 years to have been covered by the rent.
And that has been paid by me through NBSTC to KIT. And KIT has accepted and encashed this draft. This is, my lord, 5,93,000 for 81 years. The entire period of the ground rent has been paid. Now, today, my lord, my learned friend, my lord, I have taken down notes. My friend has, on behalf of KIT, has argued that I do not recognize this party. This is not what the cabinet decision was. Cabinet decision was to give it to somebody else. The fact that he could not take, and again cabinet had taken the decision to give it to MA Construction, that was not taken note of. They said that we deny, we dispute, we completely de-recognize them. Well, government is taking a stand like this. I am aggrieved. Why? Because my government is taking that kind of a stand, and which is a malafide stand. This, I am on documents only. I don't know what would have happened, my lord, if the matter had come by way of a suit. I would have been cross-examining, my lord, each of these officers. And I would have said that.
So that is also their contention, sir. The nature of transaction is not the subject matter of writ jurisdiction.
There is no dispute. I could have understood that they had raised a single dispute with regard to a single document. But I shall rely upon my lord Supreme Court judgment.
That this court has no jurisdiction to entertain
my lord,
personal transaction or contractual matters.
My lord, that was the law in 1977, Radhakrishna Agarwala's case. But my lord, much water has flown down the Ganges thereafter. My lord, law has completely changed. The judgment of Mr. Hegde, the judgment of Mr. S.B. Sinha, the judgment of Mr. Mishra, Arun Mishra, one after the other judgment, I shall just give you, lordship, the references of those judgments. I shall give you, lordship, the copies of that. They said, no, you can't say so. You are the government. No, not a single arbitrary action on your part will be entertained by the court. And if the court finds on the basis of the documents on record that there is malafide action on your part, there is arbitrary action on your part, the court will come down with heavy hand on you.
But they are saying that there has been an error on their part. It's not malafide or arbitrary. That is what they said, that your inception was faulty.
Well, I can understand I commit an error. I can understand your lordship commits an error. There is if I commit an error, your lordship corrects me. If your lordship commits an error, division bench corrects it. If division bench commits an error, Supreme Court corrects it. But here, my lord, it is not one person or two persons. Entire government machinery is
So
working.
they are taking the onus on themselves, sir. All of us committed a mistake,
All of
and
us.
there are yes, and therefore we have rectified it.
Your
That
lordship,
is what their
yes,
contention is,
yes,
sir.
their contention is, your lordship, I leave it to your lordship to believe this. And we're not accepting 13 crores of rupees by mistake. Return me the money. 1.5 crores of rupees by mistake. Return me the money. What kind of, my lord, submission is this? Have they offered to refund me the money? Today, if I file a suit for recovery of the money, they will take the point of limitation. Hey, disgraceful. That's all that I can say. This is absolutely disgraceful.
That is also their case, that you have come at a belated stage.
No, I have not. My application is, my lord, pending for that day, long time back. And kindly see, my lord, I am holding on to this property. I've sunk money in this. My lord, up to, my lord, the basement level has been constructed. My building materials are lying over there. I've spent 13 crores given to them. I've given money to, my lord, the Calcutta Municipal Corporation. I've given money to KIT. Who is going to return all these monies? Has your lordship ever asked these people, what are you going to? You are sitting on my money, and then you are fighting the litigation. My lord,
So they have disowned you absolutely.
My lord,
forget your money. They have said that we don't know him. We don't know them. That is what they said.
well, I'm very grateful to your lordship for pointing this out to me. My lord, if the government says to its citizen that, look, I shall take your money and then de-recognize you, then I won't say, I turn around and say that I don't know you. Is that a government acting bona fide? My lord, now the courts are very clear. The government in any, my lord, sphere of activity cannot act arbitrarily, cannot act malafide. My lord, your lordship says, my lord, if an individual act, my lord, wrongfully, then the government comes out and says, you have acted wrongfully, and therefore I am going to terminate your service. I am going to deduct from your salary. But what happens, my lord, when the government, my lord, misbehaves with, my lord, its own citizens? Then who is it is, my lord, that is going to be accounted for? My lord, it is like, my lord, your lordship remembers the story your lordship heard? My lord, the five persons went to a restaurant to eat, and then, my lord, if they, amongst them they started quarreling, who is going to pay? So when the bearer came, he said, you do one thing. I put this band on your head, on your forehead, on your you shut your eyes, and whosoever he will touch, he will pay the money. So after doing that, the five vanished from the restaurant. And when the bearer, my lord, tried to, my lord, locate somebody to pay the money, there was nobody. This is exactly what has happened to me. My lord, I am that poor bearer in the restaurant, and the five, my lord, persons who have eaten at my expense, my lord, they are vanished in thin air. But KIT has run away. The municipal corporation letter. Kindly see that.
Yes, they have given you the letter that you did not submit them the relevant documents.
No.
Yes,
He said,
sir.
no, I submitted.
They have mentioned that
No,
you
they
did
have
not submit those
No, your lordship says
documents.
that. Kindly see, my lord, what they have said. Kindly see, my lord. No, they have not said so. I could have understood that. They have said that, sorry, I can't do anything because KIT has asked me not to do it. Your lordship kindly see, and that letter I have challenged in this meeting.
So you come to page 130.
130.
Your proposal was accepted regarding proposal under such and such building premises. Then you were asked to submit the following documents, such and such assigned to your application, and you are advised to please quote the number of for all future correspondences,
And
then these documents were sought from you.
no, kindly see, my lord. Your lordship is, kindly come to page 130. 6th November 2010. What does it say?
So this is the earlier one.
Documents are there. Kindly see, regarding the proposal for the sanction has been accepted with reference to your application dated 6th November 2010 regarding proposal for the sanction has been accepted under Rule 4 of Kolkata Municipal Corporation Building Group to the proposed building on premises number so and so CIG scheme with the following documents, and plan is assigned to your application, and you are advised to please quote number so and so for all future correspondence. And then the reference has been given. Who says that I did not submit this? What they said was, kindly my lord come to না বলো যে ওইটা দাও যেখানে বলছি যে I am not going to give you sanction because 153. Kindly come to 153. This is their case, and this is what I have challenged in my third writ petition. All these documents have been challenged. No, এটা না 152 দেখুন। না যেখানে বলেছি যে I will not give you because AIT has asked me not to do it.
And that is in page 152.
Yes, ma'am. এই চিঠিগুলো দাও, উল্টো পাল্টা দিও না।
Yes, sir. Come to 152 and 153.
Yes, I am coming to 153.
You come to 152 and thereafter 153.
My lord, I shall come to kindly come to 152 first. 24th September 2011.
Yes. This was contrary to that letter of 6th of November 2010.
No, this is my lord.
Sir, with reference to your application dated such and such for sanction, provisional sanction under section such and such. Now, this is to inform you that the sanction, provisional sanction has been refused under 13(1)(b) of the KMC Building Rule 2009. The grounds on which the sanction has been refused are annexed herewith. That is page 153. Now, in 153, they say, it is noticed that you are not in contact should be with the office for a long time for sanction the proposed plan. So the plan proposal stands cancelled. Ownership dispute.
Ownership dispute has started by them long after this. This is what I am submitting to your lordship. Ownership dispute today. After the registered lease has been executed in my favor. Registered lease in 2010. How can there be ownership dispute then? In Bengali, there is a word, Duratta Cholir Obhav Nei. This is one of the chol minor of Duratta. I respectfully submit to your lordship that these are not to be. Every document that I am reading here, it seems, my lord, they are reeking of malafidus. One department of the government is directing another department of the government not to do this. That department of the government passing on to the message to the third department of the government, don't do this. And this is coming down, my lord, in this way. And this is what is happening. I submit to your lordship, this should not be encountered.
140 BSTC road to KMC.
Kindly come to page 140. This is the document which I wanted to show to your lordship. Kindly come to page 140. I will request your lordship to read these documents very carefully because these documents, my lord, one contradicts the other. Kindly come to 140. 31st December 2010. Drawing your kind attention of the reference cited above, issued by the Transport Department, Government of West Bengal, where it was requested that KMC should not sanction any building plan in Ultadanga premises without getting specific no objection certificate from Transport Department, Government of West Bengal. So you are requested to give sites not to sanction any building plan in the premises in the light mentioned above reference. This is, my lord, the letter which, my lord, created this this obstruction. And thereafter, they are trying to justify it by saying on these documents you have not given, that document you have not given. You return me the money. How much money have I paid? 74 lakhs or something like that. I saw it somewhere.
This is KMC tax. We have given 1 crore 62 lakhs.
Well, at page 132, 1 crore 62 lakhs has been paid. With reference to the above, we required by MA Construction, the managing director. Above letter, we'd like to inform that we have deposited rupees 1 crore 62 lakhs to KMC in the head up to date area of municipal tax.
So 1 crore 62, thereafter 2 crores.
There are 2 crore, yes. Well, the point
So
is,
nearly 3 crores?
This is my lord, on only this authority. 13 crores has been paid to NBSTC in terms of the agreement of lease. My lord, suppose, my lord, had it been an honest transaction, then then one would have said that I am cancelling it for reasons A, B, C, and D, and I am returning you the money that you have given me. That would have been a bona fide transaction, a bona fide move. I pocket the money, I cancelled it and say that you get out of it. Why? Because I am the government. I've got all the power in my hand. And this is exactly what is being shown here.
But they didn't say, sir, that they are the government, they are all powerful. They said we made a mistake.
Made a mistake at whose cost? At my cost.
That is what you said, sir.
Made a mistake? But there must
Made a
have been
mistake?
Yes, made a mistake.
Yes, sir, that is what you said. That they did not get the valid entry because there was no tender. Somehow or the other, they entered
No,
into
tender
it.
was there. Tender was there.
But it was given to somebody else, sir.
No, but then again, the second tender took place. Second auction.
Samcon, yes.
Samcon did not, my lord, participate. They did not deposit the money. So, my lord, second auction took place. I was the highest bidder in the auction. It is no gift from them. This is no charity.
But they are considering Samcon, but not you, sir.
Samcon?
They are considering Samcon, but not you.
But Samcon won't pay the money and Samcon won't come in. So they are left high and dry. Then what do they do? Again, the cabinet committee holds a meeting and my lord, they said that yes, give it to somebody, make a fresh auction. Fresh auction takes place. I am the highest bidder. I have come in. It is by auction.
But then, sir, later on they received a legal opinion that yes, the then Advocate General gave a legal opinion that they were on the wrong side of the law. They shouldn't have accepted your proposal.
That's right. They should not have accepted my proposal. Then what should they have done? They should have sat on my money and they reissued a letter. This is ridiculous. It makes me laugh. This is exactly what they have done. Yeah, and see, my lord, the notice of cancellation, termination. Kindly come to that. This is my, on fact, my lord, this is the last thing, and then I shall go into some of the decisions. Kindly, my lord, come to that. They are cancelling it on what ground? Termination, cancellation of contractual relationship and resumption of possession of 109.49 katas of land comprised in the Ultodanga bus terminus, so and so. This is with reference to NBST. Note, this is page 157A. 157A. Kindly similar paragraph 2. You are made fully aware of, and you are aware that. What am I aware of? We, in our affidavit in opposition, filed in response to your WP number 15313, which is before your lordship, had stated to give you notice that we had in our 216 board meeting held on 30th November 2015 for very many reasons. Note the words. For very many reasons, had decided to terminate, cancel, and the said purported agreements. dated 22nd February 2002 and dated 31st October 2003, and the purported registered agreement dated 23rd April 2010, as also the purported power of attorney dated 21st August 2002. At the said meeting, a resolution was also adopted to such effect and also to revoke the said purported power of attorney dated 21st August 2002. You duly accepted the said notice and took inspection of the minutes of the board meeting pursuant of an order passed by the Honorable High Court, which you obtained on 21st January 2016. The said inspection was obtained by your advocate on record along with your representative on or about 3rd February 2016. The fact of the decision to terminate and cancel the said purported agreement, etc., was also duly recorded in the said order of the Honorable Court dated 21st January 2016 of so and so, which was filed by you. On the said date, your writ petition number so and so was also in the list of Lordship, Honorable Justice Abhijit Banerjee, for your ready reference, a copy of the said order. In spite of the aforesaid, you wrongfully and illegally, instead of handing over possession of the said captioned land to us, you have been wrongfully and illegally pursuing your writ petition. Kindly see the threat that you withdraw the writ petition. Pursuing your writ petition, hearing number WP 15313 and of 2011 and bearing number WP number so and so 2011. We would request you to refrain from the aforesaid stance of, kindly see, we will request you to refrain from the aforesaid stance of yours. Well, kindly pause here for a moment. What does it mean? You withdraw the writ petition. This is a threat by the government from the aforesaid stance of yours and peacefully hand over possession of our said captioned land to us at the earliest. Otherwise, we shall take appropriate steps to take possession of the said captioned land as we may be advised. Further, we hereby once again reiterate to give notice to you and inform that the aforementioned purported agreement stands cancelled and the aforesaid purported power of attorney executed and so stands revoked, inter alia, in view of the shift in public policy. This is the ground. Shift in public policy, and more particularly in view of the orders of the Honorable High Court passed in a public interest litigation number so and so. What is this? What are these?
What was the order passed in this?
I don't know. I will not know. They have not come forward to say so. And how am I concerned? How am I concerned? This is not the ground for termination.
No, this is what? Directing shifting of the bus terminuses from Esplanade in terms
of the bus terminus from Esplanade in terms of the recommendation of the High Power Committee formed in the self-same public interest litigation earlier. Since NBST sees no other suitable property in or around city of Kolkata, it was decided to utilize the captioned land in its Uttaranga bus terminus to accommodate inter alia our buses, which otherwise would have been parked at Esplanade terminus. We hope that good sense will prevail upon you. The father is admonishing the son. We hope that good sense will prevail upon you, prompting you to refrain from your wrongful and illegal claims against us. In respect of the pending writ petition, this is what they are saying. As also to make over possession. My lord, arrogance, my lord, when it reaches the limit, this kind of a letter is written. This is nothing but an expression of arrogance. This, however, without prejudice to our rights and contention. My lord,
so this termination.
What is the ground?
So this order of termination. How
is the order of termination?
So this order of termination did never mention that they have received a single penny from you.
No, there is no ground. What your lordship has
So then you have not given them any. You are claiming to have given them more than 18 crores.
Yes. And
so they are saying they did not mention that.
No mention. Why should
that means you haven't
money is in their pocket?
That means you haven't given them anything.
My lord, most probably that money has gone into the the clubs. Distribution among the clubs. That is also without prejudice. My lord, The government cannot act like this. The government cannot. This letter of termination does not contain any ground which will entitle them to forfeit the lease in terms of section 111, section 111H. আমাকে transfer of property act আছে.
Sir, we will continue tomorrow. I have some FMA
Very
matters,
well,
sir.
madam. Tomorrow, kindly do not make it tomorrow. Tomorrow there is one at 3:30 already made, and tomorrow.
But somebody told me that prior to Puja vacation, there won't be any 3:30. That is what the Secretary of Bar Association.
My lord.
But no action has been taken, my lord. No decision has been taken. No effect has been given.
No, for
tomorrow.
My lord, like the government, my lord, the bar library club and bar association also resigning from their promise. Yeah, yes, of course.
How can he himself?
Well, your lordship can keep it in the daytime. Your lordship can keep shop in the morning.
Sir, morning it will be very.
Then, my lord, kindly make it next week. Because I want to finish this, my lord, I shall just place 1 or 2 paragraphs of the judgment. I have, my lord, on fact, my lord, I have told your lordship, this particular submission of mine meet all the arguments of my learned friends. I shall indicate to your lordship how it does. And my lord, this is something, my lord, my learned friends should consider. It's a registered lease. You are terminating a registered lease. Can you just say that I am?
Sir, they said they made a mistake. I mean, orally, of course. Orally, they said you should not have been granted. And
once I have been granted, then they will have to legally terminate it. If they do not legally terminate it, then, my lord, it becomes arbitrary action.
So their termination order did not mention that they have received anything from you. Whatever modicum amount it can be, that also they have not received. So where did you pay, sir? To whom did you pay, sir? KIT did not say. NBSCC did not say.
Of course, letters are there. Recording.
No, the termination order did not mention, sir. That is the ultimate.
I am challenging the termination order. The termination order did not mention the amounts of money they have paid, which they have acknowledged in writing. Acknowledged in writing. Well, this is, I tell you, lordship, my lord, the more I see it, the more I feel sad about it. That much I can tell you, lordship. Well, I shall come back to your lordship and make my submissions and finish it. This is one of the glaring cases of arbitrariness and malafide action that I have seen on the part of the government.
And they are saying that this writ court doesn't have jurisdiction to deal with.
I shall show to your lordship what the writ court says. I shall show to your lordship what the writ court says.
And then they said that they have made a mistake. The moment they realized that they committed a mistake, so they refrained from continuing with the same, and therefore they terminated your agreement.
Well, I wish, well, I could have said that to your lordship and be excused for that. Come before your lordship and say I made a mistake. Please don't mind. And my lord, whatever.
No, so they said that.
No. I say.
Well, I said that
No.
there was an error. There was a mistake committed by them, and once they detected it, being an authority, they shouldn't have continued with it.
Well,
that was their submission.
I wish, my lord, I could make a mistake and put money in my pocket, and then not, my lord, take it out. This is a very attractive argument.
I'm sorry,
No, your whatever you said, sir, I think I could reiterate that,
yes,
sir.
Yeah, lordship. Lordship has been reiterated.
I apologize.
I think I made up for you.
Lordship.
All of you.
Well, on which day will it be convenient? Kindly give me one more day. I will finish my.
Sir, I thought I would continue on 2 consecutive days.
That's what your lordship told me. Yes, that's what your lordship. Well, kindly give me one day before the vacation so that, well, I don't forget it. Well, next week, give me from 3 o'clock to 4:30.
21st, again, that will be dicey if you people come up with a 3:30.
Yes.
If your lordship defies 3:30, then I defy.
I am there to defy.
Then, my lord, I shall assist your lordship to defy.
I generally defy.
My lord,
The FMA, they are smiling, you can see.
But I understand 3:30 minute is not now only confined to Fridays minute. So otherwise.
Hold on. 20th?
No, হবে না।
20th August.
20.
Or 20th, 21st, 22nd, and any day, my lord, convenient.
19th, 20th.
24 হচ্ছে।
So then, can we keep it 20 and 21?
Your lord, can you keep কোনটা?
কার্ড আছে? এখানে কাটতে দেন না।
My lord, on the 20th, my lord, at 3 p.m., my lord, division bench has fixed a matter for me. Just now I heard.
Then you come on 21st?
21st.
3 p.m.
আমি বলবো তো, আমি তো বলবো তোমাকে দরকার আমি তো বলে দেবো আমি কি বলেছি, তোমায় কি গালাগাল দিয়েছি আমি সব বলবো।
এইটা তো হয়েছে না। Heard the submission of learned advocates representing the petitioner as well as the respondents. Next date we fixed on 21st then.
Lordship.
21st of August at 3 p.m.
বন্ধ।
Lordship.
Grateful to you.
Orders together. For orders, Achana? Yes, for orders. Until ticket pass over.
আমাকে কেন দিই?
But in this matter, I am for respondent cross-objectors. There are two can is pending, can 1 and 2. One of delay condonation and another 2 of 24. 2 of 20
Condonation by you in cross objection.
in cross objection. And another one when there is amendment, the name of the cross objectors. The amendment petition that's Nageshwar has been written by in the claim application and cross objection and my its appeal. Nageshwar spelling was Nageswar.
It's written in the claim application, sir.
There
Mistake on your part in writing the name?
No. This is my, your lordship, see the judgment.
Judgment also.
Nages.
Yes.
WAR.
Yes.
SHAW.
But thereafter in the PAN card, the Aadhaar card, there is NAGE after the SHWAR. One H will be insert.
First matter dispute of the stay application. This is my
State absolute.
Can 1 of 23.
a cross appeal is cancelled.
Cross appeal is can. 1 of 23.
Can 4376 of 2016, it's yours.
Yes, আপনার দুটো পেন্সিল।
It is stay.
দুটো দুটো ডিসপোজ হয়ে গেছে।
4376.
Actually, my lord, this is a very old matter.
Very old matter. Can application কোনটা? না এই রেকর্ডে একটা আছে। 1 of 23.
1 of 23.
This is
In which
delay
court did you
condition.
file?
Delay condonation.
In which court did you file?
No. No.
So you try to recollect and come back on the next date.
मतलब ये can application is can नहीं. Then another one मतलब 2 of 25 is here.
2 of
24 subsequently
Sir,
it was
first you get your cross objection on record. Thereafter,
yes, my lord. Oh. কি হচ্ছে আমি বুঝতে পারছি না ক্যান অ্যাপ্লিকেশন আছে
department. Sir, your stay has been made absolute. The department is directed.
one thing Milord, one thing another LCR has been come. Would kindly
Sir, first of all, get your cross objection admitted, and thereafter you condone the delay first. That application is not on record. The department is directed to place the CAN application along with that of the
আমি
main
নিজে
on the
দেখেছি
next
পেপার
date
সেকশনে
hearing.
ছিল দুটো ক্যান ছিল এই পেমেন্টে
Next date we
একটা কারেকশন হচ্ছে
fixed on 28th of August, sir. By that time, let them trace out the CAN applications.
আচ্ছা
82 কি আছে? Hello? দেখি রেকর্ডটা। None appear to represent the apparent insurance company on second call. Let the matter go out of the list. সেভেন্টি 76 একটা আছে হয়ে গেছে তাহলে 108 Yes, sir.
This is my appeal filed by the insurance company on the ground that vehicle offending car was the owner of the vehicle obtained the private car policy, act only policy for his private car. And at the time of accident, he was carrying passengers in the said car. My lord, as per decision of the Supreme Court, that private car not permitted to carrying passengers. And as per Act policy, not permitted to the insurance company to pay the compensation. Now, this is only point.
How has you have taken this point before the tribunal?
in the written statement, nowhere it has been stated.
My lord,
And
policy has been exhibited.
nowhere it has been said. My lord, this is a question. My lord, this question is mixed question of fact and law.
This
Your
is a
lordship
question
knows
of
that.
law, my.
No, mixed question of fact and law. This will have to produce the policy copy and also by evidence, my lord, that has to be proved. Our High Court division bench also held that. And first time in appeal, that cannot be, my lord, taken into consideration.
My lord, your lordship, page 34. Copy of
30?
34.
That is the policy. At first, my lord, written statement has to be taken into consideration. No evidence has been adduced regarding liability.
So this policy cannot be read.
Yes. My lord, LCR is there.
Absolutely illegible. Did the tribunal deal with it? You are saying that this issue was not taken up before the tribunal?
No.
Written statement mentioned it.
Written statement, no, nothing mentioned regarding liability, act policy, nothing. There is no specific pleading should be there. Otherwise, my lord, that cannot be.
What is the amount of compensation granted?
4,50,000. This is the injury case. 70% disability that has been exhibited, my lord. Thereafter, my lord, the tribunal below calculated the amount 6 lakh something. Since, my lord, the claim was 4,50,000, tribunal below restricted the compensation to the extent of 4,50,000. Though, my lord, calculated 6 lakhs odd.
There is a difference, my lord.
That question has to be raised, my lord.
এখানে তো পলিসি ফাইল হয়নি।
পলিসি ফাইল হয়েছে তো। ওখানে বলা আছে একটা জায়গায় that has to be proved. Paragraph 11 না করে
মানে প্যারাগ্রাফ 22, 20
তার আগে আছে আছে ওখানে না ওটা আছে এখানেই আছে না স্যার এখানে আছে
There has been no discussion. There has been no discussion either by the tribunal or High Court in this regard. It is before us. Annexure P1 has been filed, which is policy issue. It inclined to think that there has তারপরে বিমান
হবে না, তার আগে আছে।
So it is not absolutely in your favor, sir.
I bow down my lord.
As per my lord,
It is not, sir.
it was not, my lord, argued before the learned.
Yes, it was not argued.
Therefore, my lord, submitted before your lordship to remand back the matter for re-hearing.
That is by and between the owner.
Adducing further evidence.
No evidence cannot have been.
As per the direction of the honorable advocate.
Beyond pleading, my lord, that can be. Beyond pleading.
So you give him a copy of this judgment? Of this judgment? You go through paragraph number 21.
Yes, madam.
22 and 23.
Yes.
And come back tomorrow.
Madam.
Yes.
No. Okay,
On the submission of learned advocates representing both the parties, let the matter be adjourned for the day for further
my lord, I submit.
hearing.
But I'm sorry, my lord, at time 82, my lord, I couldn't reach, my lord. I was coming from courtroom number 10. It takes some time, your lordship. And the board updates a bit slower, my lord. Kindly appreciate, my lord. I was here, but that matter was continuing, so I had to rush, my lord.
110.
My lord, 82, my lord. Kindly, your lordship has probably made it out of list, my lord.
So on the other day also you were not there.
My lord, other day I was here. Today morning, my lord, I couldn't. My lord. Unfortunately, all the matter clashed, my lord. It's an unfortunate day for me today, my lord. At least takes it up tomorrow, my lord.
110 Shubhankar Mondal. You are there?
Yes, madam. This appeal of Mr. Mondal, my lord. Mr. Ashif Mondal is there for him.
And next week? The learned advocate representing the appellant insurance company is present. Mr. Mondal will be representing the other Mondal?
Yes, Mr. Mondal will be representing the other Mondal.
None appeared. No, it appellant insurance company now. Respondent insurance company. None appeared to represent the appellant claimant. Next date be fixed on 19th of August,
19th.
112/13, same.
You know, this is same. Your Lordship remembers, Your Lordship had directed the police station to bring in those records, you know, same. 19th.
Oh, in একই order, আগেরটার মতো. But sir, here you are the appellant,
Yeah,
right?
in this case, in 112, I am the appellant. my lord.
তাহলে উল্টোটা হয়ে যাবে. The
With
learned
cross objection,
advocate
113.
representing the appellant insurance company is present. None appear to represent the respondent claimants. Next date be fixed on 19th.
19th.
117.
117, my lord, I am for the respondent owner, my lord, respondent number 2.
Your Lordship, on previous occasion, I have indicated before Lordship during filing the paper book that this appeal should be dismissed as in the case it's below 1 lakh. As the appeal should be
76,500.
appeal should be filed over and above 1 lakh, and that's why I indicated that it should come from the claimant side, and the appeal should be dismissed today itself. And they should get the money as we have secured the entire sum before the learned registrar. It should be given to the claimant. Only submission that what
No, that is what is actually your submission?
my actual submission is this appeal is maintainable and this should proceed. But
Chanchal. 118.
Two grounds I have taken. That is one malat invalid driving license, another malat that's a higher rate of interest malat. Invalid driving license and second is malat higher rate of interest. 8% interest was granted malat. That's two grounds. First ground malat kindly come to malat page 21. Deposition of RTO. Page 21, third paragraph.
What is the name of the driver?
Fellowship will kindly come to page 27, that is the scissor list. Page 21. No, sorry, I'm sorry.
Where is the chart
27?
sheet?
27. Page 27. That is scissor list. Your Lordship will kindly at the bottom, column 5, list of seized article, malat column 5. Driving license number.
Name of Khakon Sheikh.
Khokon Sheikh, yes, malat.
Khokon Sheikh or whatever.
Yes, malat.
Then?
Chart sheet, malat, page 25 is chart sheet. Page 25, your Lordship will find at column 11. Page 25, column 11, particulars of accused person charge sheeted.
Yes, so
Yes.
it is in his name only.
Yes, my lord. That is the driving license. The Khokon Sheikh was valid. Date of accident is, my lord, 17/5/2012. 17/5/2012. The driving license was valid from 28.
Yes, as per the driving, the license was valid till 11/6/2009.
2009 and the accident occurred in the year 2012. Date of accident is 17 May 2012.
Then there is no note in this driving license extract that no renewal of this driving license of
Since there is no
Sheikh was done after. Wait, it is a fact that the entry as per this driving license extract, what happened after 2009, there is no record to that effect either manually or in the computer, and it is not possible for me to say anything about the computer
because there was
entry.
no entry. That is why that has not been reflected in the report
It
of
is
the
not
RTO.
to say anything about the computer entry or against them. So it's not.
Since there was no renewal or there is no entry,
So
that is why
that is your perception.
Yes, already that
I will record your submission.
Lord.
And what else?
And 8% interest was granted.
Achha.
Can you grant me liberty to prove at least prove my case? At least prove my case. So that I can. Yes, my lord.
What did the tribunal say?
Tribunal findings of the learned tribunal is, my lord, page 40, 41. Page 40, my lord, second paragraph, the learned advocate OP number 2.
So you never, you only stated that the driving license was not valid.
Yes, my lord.
So
And,
you did not seek pay and
and for
recovery?
such purpose, my lord, that evidence has been adduced by calling upon the concerned RTO to, my lord, prove that whether the license was valid or not.
Let's say it is not possible for him to say.
Because possible not because there was no entry. That is what the report says. But that driving license was valid from that day to that day.
Now it is stated that considering the aforesaid evidence and also considering the Caesar list, Exhibit 4, it can safely be said that the accused driver had valid driving license at the material point of time. This is
Malat,
what the
on the basis of Malat entry made in the Caesar list. These findings, Malat, there is no other evidence because Malat driving license of the driver that was not exhibited before the tribunal.
8% to 6%.
Malat, driving license was not exhibited from the side of the claimant. Owner did not contest the case. Malat, only in the Caesar list, the date mentioned is that the driving license was valid. That
What else?
only on that basis, the learned tribunal came to a finding that yes, the driving license was valid.
After your matter, I will take another matter. Right? Don't waste time.
Only Malat,
No.
only let me prove my case.
The learned advocate representing the appellant insurance company. Why take chances? You can, by this time, you should have understood.
No, adduced evidence, Malat.
This is the evidence has been refuted. The Caesar list is against you. Have submitted to have filed the instant appeal solely on the ground that the driver of the offending vehicle did not possess a valid driving license which expired after 11th of something 2006. 11th September.
No, driving license, Malat, expires on 11/6/2009.
11/6/2009. And the accident occurred on
17th May 2012.
17th May 2012. The learned advocate representing the appellant insurance company further submitted that on the date of the accident, the driver of the offending vehicle did not possess a valid driving license, which appeared to be believable from the deposition of the
RTO.
Concerned
RTO.
representative of the RTO or the
Only I post representative of the
RTO. Being PW?
OPW1.
OPW1.
RTO Hooghly.
RTO Hooghly. Full stop. Moreover, the tribunal had granted interest to the rate of 8% per annum, which had been excessive. The learned advocate representing the respondent claimants submitted that the learned tribunal, considering each and every aspect as well as the deposition of OPW1 being the representative of the RTO Hooghly, had reasonably considered the driver of the offending vehicle to have been in possession of a valid driving license. Good stop. Sincere paragraph, the Parata. The learned tribunal in the impugned judgment and order has inter alia observed as follows. Which page did you point out?
Findings or deposition.
No.
Deposition at page 21.
Page 40 থেকে page 40 থেকে Deposition of OPW1 is in which page?
Page 21. And cross-examination portion is at page 22.
The evidence of OPW1 in his cross-examination stated as follows. Considering the submission of the OPW1 as well as the Caesar list marked as Exhibit 4, the opinion of the learned tribunal as stated above in the impugned judgment and order appeared to be absolutely correct and should not be interfered with. However, the compensation amount as granted by the learned tribunal is modified to the extent that the sum of rupees, how much was the sum?
7,70,000.
7,70,000 is to be paid along with the interest at the rate of 6% per annum from the date of filing of the claim application till the date of its realization.
Right, my client has already deposited the
Next.
Milord 121, 122, Milord, is insurance appeal and claimants cross objection. It's an injury case. Milord, it will take some time, Milord. The Lordship will take it up tomorrow because, Milord, for 50% injury of a 41-year-old gentleman, Milord, 50% disablement certificate being issued. Milord, the corresponding loss of income has been considered to be 50%. Milord, he was a civil contractor. So, Milord, that I would be challenging before your Lordship, Milord, because the injury was confined to the right leg of the gentleman and loss of income was not, Milord, shown properly. So, Milord, it will take some time. Milord, I will be relying upon judgments also. Kindly, Milord, take it up tomorrow. We'll do it. Otherwise, Milord, we can do it today itself, but it will take some time. It will eat up the time of other matters, Milord, if these are short.
Then this is the last matter I will take up.
Milord, there is one very small matter.
My lord, yesterday with Mr. Afroz was going on, my lord, that is the income tax return. My lord, gross total income net to my lord has not been.
Is he there in this matter?
No, not in this matter.
Not in this matter.
My Lord, your Lordship said this was the last matter my Lord was thinking of taking. And since my Lord, if my Lord does not take up this matter, my Lord,
You mean to say since he's irregular, that is why?
No, my Lord, I did not say that. I did not mention Mr. Alam's name.
No.
My learned friend.
That can be disposed of.
So you are more on his side. That tomorrow he might not come. What? Tell me.
My lord, that may be, my lord.
What?
He was saying that.
At 4:45 with regard to the Lok Adalat at Mediation Council, my Lord.
So you people have to go there?
My Lord, at least I have to go there. Mrs. Paul would be going there. Some of us should go there, my Lord. I do not know who.
He's not accepting.
My Lord, I never. Lord, if Lord, Lord, I have to go there. Otherwise, it would be Lord a fruitless meeting. I have to go there.
It is true.
Tomorrow I can do that because this part has been regularized.
Yes.
So for tomorrow I'll take up the forwarder matters first and thereafter your applications.
Grateful to you, Lord.
Okay.
Grateful to you. I'm deeply obliged.
What else? আরেকটা ছেলে কি বলছিল?
There are two forwarders matter in which the courts are not appearing. If they don't appear, the matters.
Which matters?
I did 149. 145.
ওই একটা যেটা বলেছিলাম go out of the list এর রেকর্ডটা কোথায়?
149. টাকা হোক কথা দুটোই আমি আছি করে দিচ্ছি।
Now he's not there. The one who had just come. He should have waited. Well, take a
but the chords are not appearing. It's there in the 145 and 149. Both the items, chords are not appearing. That should appear in the list.
So these are fixed for orders.
For orders. Today's fixed for orders. Item number 145 and 149.
What number?
Code number one.
Who is appearing for the respondent?
Also, I am appearing for the claimant respondent. I also filed court number.
Give the numbers.
And for 149, he is appearing as a respondent.
Well, code number 127.
Just write it in
As
a
is
slip
given.
and give it to them. And then give it to them.
Given.
So tomorrow I'll take up for orders first.
Yes, sir.
And this mediation matters.
Yes, mediation management are from Monday onwards. I believe.
Yes. So the mediation matters are given the date also.
Yes. But we have to sit together. We have to see whether how many of those can be done. Yes.
What? How many? It has to be done. What do you mean by how many? We have been allotted 52 matters, right? So in any case, now who is a group leader? You are the self-proclaimed,
Never,
accepted by the others.
Never self-proclaimed. Never in this life.
Conveniently, at times you become their group leader. When you act against their insent, you become the villain. So first of all, you assure yourself.
As per their convenience, it's not as per my convenience.
That's exactly what I'm saying.
Yes.
That's exactly what I'm saying. Convenience is the key. So when they want you, you become their boss. And when they despise you, you become the villain. So now, who else will be there with Mr. Singh to become the boss? Or the hero or the leader, Mr. Roy? And where is the other one, Mr. Monique? Two from the insurance side and two from the claimant side. Along with you.
I have got information about 30 of these matters in which the different advocates have been allotted and they have been appearing, respective advocates. So, these are not my matters. Maybe I have got 2 or 3 or 4 of those.
Who is asking you that it is your matters? I am asking you to monitor, class monitor, prefect.
Yes.
Your husband to allotted, we will do it. By hook or by crook. No, then they have to be brought on.
They have to be. I'll see.
Otherwise, then we'll send across my last weapon.
Administrative.
Okay.
I have to call, but he says I'm coming. What can be done?
He's busy elsewhere. I given.